All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, your attendances shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Wednesday, December 4th, 2024. I'm Justice Joseph Ditkoff. To my right is Justice Marguerite Grant, and to my left is Justice Robert Toone. He's the most junior justice right now, but by the time we finish, he will no longer be. There will be two judges junior to him, so we're very excited for him. We have some people who are new, so I'll go through how things work here. We have a clock here. When you're arguing, it will count down from 15 minutes. When there's a minute and a half left, it will turn yellow and keep counting down. Once you run out of time, it will turn red and we'll start counting up. When it's red, that isn't time you have left, that's time you're over. When it turns red, please finish your sentence. But nothing else unless you're answering questions from a judge, in which case please finish your answer. There's no rebuttal in the Massachusetts Appeals Court. Once you've argued, that's it. We have read the briefs. We have gone through the record. We are familiar with the issues. We've taken copious notes, so you should get right to your argument. You don't have to give us a summary of what's going on. All right, with all that being said, I'll call the first case today, Commonwealth versus DELACRUZ, number 24P. 344. Counselor, whenever you're ready.
Please the court, Adriana Contratesi for the defendant appellant, Mr. DELACRUZ, who contends he is entitled to a reversal of the denial of his motion to suppress and a remand to the trial court to enter those findings and a retrial. I think that the Commonwealth, I'm sure not intentionally, slightly misstates what the issue is, what the issue that I stated is. And what the issue is in this case is whether or not the police unconstitutionally escalated an otherwise unjustified search into the trunk by just saying that they were going to frisk the trunk before they gave the car over to the friend. That is the kind of unjustified escalation. I think that the best analogy I can make is in Commonwealth versus Narcisse when this court in the SJC addressed these field interrogations and found that the Boston police were escalating otherwise consensual encounters and falsely creating reasonable suspicion to search people. I have the citation for Narcisse if the court would like it. That's 457 Mass 1. And at 9 and 10, well, at page 9, the Narcisse court specifically says, we state expressly that police officers may not escalate a consensual encounter into a protective frisk absent a reasonable suspicion that an individual has committed, is committing, or is about to commit a criminal offense and is armed and dangerous. And that is the same thing that we have here. At the point that the officer told the defendant that he was going to frisk the trunk before he handed it over to the defendant's friend is when the unconstitutional escalation occurred, and everything that comes after that should be suppressed.
So just is your position that the idea that the car should be frisked in some capacity before it be turned over, was that improper? If you're handing the car over to a friend, is it improper for the officer to sort of say, well, I got to make sure there's no weapons, at least in the front part of the car?
Well, we concede that the arrest was lawful, and the police were entitled to do a frisk of inside the car pursuant to the automobile exception. But there was no reason for the police to be in the trunk. And as a matter of fact,
so just to be clear, that saying I'm going to frisk the car as to the part that was in the trunk, that wasn't problematic in your view?
No, they were entitled to do that pursuant to the valid and justified arrest
So
of the
what
defendant.
was the part then that you said accelerated into an unconstitutional encounter when he said, I'm going to look in the trunk as well?
So the defendant had made arrangements for a friend to come and take the car. The police had agreed to that. So pursuant to the Boston Police's policies on impounding vehicles, if the car is going to be given over to a friend, there is no inventory search. So the unjustified escalation occurred when the police officer said to the defendant, "We'll give it to your friend as soon as I frisk the trunk." That was an investigatory purpose only. He had no reason to ask that. There had been no reasonable suspicion. The arrest had gone smoothly. All the stuff that everybody talks about, the trial court, the DA, and the judge, even in her findings about the defendant being nervous, none of that happened until after the police officer said he was going to search the trunk.
The judge didn't find that. The judge says the officer explained that before the vehicle released, the officer was going to frisk the car. Is that wrong? You just said that he said that he was going to frisk the trunk, but the finding is frisk the car.
The officer said he was going to frisk the trunk.
But that was after the defendant said, when the officer said, we're going to frisk the car, and your client said, but you can't look in the trunk without a warrant. And then the officer said, no, we're going to frisk the trunk.
I might need to stand corrected, but I believe that the police officer said he was going to frisk the trunk. I think I have a citation.
Right, but your client said you can't look in the trunk without a warrant. You're saying it was the officer who mentioned trunk before?
Yes, yes. And
I'll check that.
And that was, okay, thank you. As I said, I might have to stand corrected.
I said I'm going to check the motor vehicle because I'm handing it over to someone. I want to make sure it's safe to do so. At that point, he said I could check the inside but not the trunk. That's the testimony. What should we derive from that?
Well, that was a correct statement of law. And the officer unconstitutionally escalated that search when he began questioning about the trunk. He only had an investigatory purpose in pursuing that.
At the moment in time when your client is handcuffed in the back of the cruiser and his friends haven't yet arrived, is the Honda in the custody of the police?
No, specifically not. If you look at, I had the same question, but when you refer to the Commonwealth Supplemental Appendix at page 6, it says right here, the reason why a car being handed over to an authorized person to take it away does not need to have an inventory search is that it's not in the custody of the Boston Police.
Is there a difference between cases where the person who's taking the car is already a passenger and the defendant says they can take the car versus someone who's coming to the scene?
Well, I think that there's a little bit of misstatement in the motion court's fact finding too. I mean, the defendant was not disoriented. The defendant was just looking for some confirmation of the address, and the friends had arrived shortly thereafter. So no, I don't think so. I mean, maybe if somebody is a long time away, the police certainly shouldn't have to be expected to stand there for 30 minutes. But there's a lot of good reasons against impounding a car.
If someone shows up or they're a passenger and the police are concerned about accusations of theft from the car, are they allowed to run the record of the person, the substitute driver, to see if they have any larceny convictions?
Well, that's testing above the pay grade of my brief. I don't really see why that would happen. I think that I think that if that did happen and this issue was here, I think that the court would be asked to balance the interests of the financial disaster and inconvenience to the owner of the car to have their car improperly impounded against this potential record that the authorized user might have. Because even if the authorized user took the car and did something terrible with it, I don't think that the owner of the car would have any recourse against the Boston police for having done what the authorized owner of the car had asked the police to do.
But you'd have to run the driver's license of the person who shows up, just to make sure it's still valid, right?
Well, I think that would be fair, yes.
You don't have to, but you'd be reasonable to do that.
Well, I think so. I think that was, I think, well, the police probably would do that, yes.
What do you do with El Hiabi, which construed very similar, or the same inventory policy? That's the SJC case.
Yes, that case is analogous. Well, it's like, I mean, that case is analogous because there was an authorized person that could take over that property. And that is the foundation of the reason why the police were not entitled to do an inventory search of the backpack, because it was being handed over to an authorized person so that the backpack was never in the actual custody of the Boston police, and nobody could come back to the Boston police and allege any of those reasons why supporting an inventory policy.
At the moment when the police searched the trunk, what level of suspicion did they have? Was it a hunch? Was it probable cause? Was it something in between, like reasonable suspicion? Where on that spectrum was there suspicion?
No, I think that after that happened, the police did have reasonable suspicion. But it was a reasonable suspicion that the police created themselves. And that is really the issue. That at that point, when the police said, against all policy and without any justification, we'll hand over the car to your friend as soon as we frisk the trunk,
But the inventory policy says that under Category 4, have it towed for safekeeping. That's when there's a danger to public safety. So why isn't it proper for the officer to ask, is there anything in the trunk, in determining if there's a danger to public safety?
Because in this case, it falls under Category 1.
And once the officer says, yeah, you can call a friend, that's it? He can't change his mind?
Well, the officer can change his mind, but not after he's improperly escalated the encounter to allow him to change his mind. I mean, you're not supposed to tow a car unless it's absolutely necessary. The SJC has made that very clear, and anybody who has had a car towed or had clients who have had a car towed or even have thought about the difficulties of somebody having to get over to that tow lot to pay those exorbitant rates. I mean, there's excellent reasons beyond criminal issues why the SJC has really pushed back against an inventory policy that goes unchecked. And so we are not dealing with policy, question number 4, paragraph number 4 here. We're dealing with paragraph number 1. Now, have it towed for safekeeping. Those are instances, and the Commonwealth cites those cases in their brief too, where, well, the car was stopped on private property, the car was left in a bad neighborhood, and there was nobody to come and pick it up. So that's what safekeeping is all about. The car just wouldn't be safe left there. Not that there might be something inside the car that would be unsafe for people to break in and find.
Counselor, let's pretend that the facts are that all the officer said is, I'm going to check the motor vehicle, didn't say anything about the trunk, and then your client immediately said, well, you can look inside, but not in the trunk. If those were the facts, do you have an argument?
Yeah, well, I mean, he was Mirandized when he was arrested. So if he hadn't been Mirandized, I think well, in this case, the defendant was Mirandized, and I think that Well, yes, I think that it could go either way, depending on what the other surrounding facts were. I think it could go either way, depending on what.
Why? Well, I mean, if the defendant says you need a warrant to look at my trunk, why does that change your position?
Well, the panel's question was, if he said, I'm going to frisk the car, and somebody said, well, you can't go in the trunk. I think it could go either way. Some court could find that that was an improper escalation right then and there because it was such a general statement. It was escalating the justification to go in and search when there wasn't any justification. And on the other hand, a court might find that that would give rise to reasonable suspicion, the same way that a defendant appearing nervous and stressful in some situations can also give police officers a hunch that might build on reasonable suspicion. So I think it could go either way. But in this case, I think it can only go one way, and that way is that it was the police that unjustifiably enhanced that encounter.
So Judge Coffey ruled that even if it was not proper as an inventory search, it would have been proper as an automobile search. And I didn't see in your brief that you made an argument in response to that. Can you just summarize what your argument is?
Well, I think that law is wrong, and this panel is entitled to correct that, because the automobile exception doesn't have anything to do with the trunk, and Commonwealth versus Cast doesn't have anything to do with the automobile exception. Commonwealth Cast was both prongs of the cases are slipping my mind. The two-prong test of.
Aguilar-Spinelli?
Thank you, Judge. The two-prong test was met. There was police corroborated, confidential informant information all over the place. They were right on everything. So, I mean, there was no question that 2 kilos of cocaine would be in the trunk. But that's not what the automobile exception is about. The automobile exception strictly speaks to inside the car, the glove compartment, says nothing about the trunk.
There aren't any automobile exception cases about a trunk search?
Well, if you want to extend it, but as I said, Commonwealth Cast had nothing to do with the automobile exception and everything to do with Aguilar-Spinelli.
All right.
All right, thank you.
you very
Again,
much.
I do ask that the court reverse the denial of the motion to suppress. Thank you.
Thank you, Counselor. We will hear from Ms. Conkey now.
May it please the court, Lindsay Conkey with Assistant District Attorney Darcy Jordan, supervising for the Commonwealth. This court should affirm the denial of defendant's motion to suppress because the firearm was found as the result of a legal and properly executed inventory search where the changing circumstances made it no longer reasonable or practical to continue to wait for a third party to arrive. Specifically, the defendant was displaying increasingly suspicious behavior. He repeatedly asked the officer about his trunk and reminded him that he needed a warrant to search it. He gave evasive answers about what was in the trunk, especially after admitting that he had marijuana in the car, which leads to the inference that whatever was in the trunk had been more incriminating than what was already found.
More incriminating, what's the incriminating part?
The fact that he was willing to admit that he had marijuana, which I know
Why
is
is that-
not illegal,
why is that-
just because it is a drug, and the fact that he had it in the car next to the driver's seat.
That's incriminating to say you have marijuana in Massachusetts to have marijuana?
Not incriminating on its own, but the presence of
You
drugs.
said more incriminating, so what's the initially incriminating part?
The fact that he had drugs in an somewhat open container in the car in the driver's side.
He didn't say he had them in an open container, right? There's nothing.
Correct.
He said,
It was
honestly, I
found
got some
open.
weed in there, right? So it could be packaged, could be anything, right? There's
Right.
nothing, that's not an inherently incriminating statement, right?
Correct, it's
So
not.
when you say more incriminating,
Sure, then sure. Initially incriminating.
Okay.
The fact that he wasn't willing to say what was in the trunk when he was open about what was in the car, I think that there's an inference to be made that he knows what's in the trunk is going to be incriminating.
why? Why?
Because-
Why? Do you have an obligation to sort of disclose the contents of your trunk to an officer who stops you?
No, certainly not. But you probably would not be nervous about it in the same way that he was. As soon as he heard the car was going to be frisked, that was his first thing, was to remind the officer that he can't go in the trunk. And then he went on to say, it is what it is, you're going to find it.
Isn't it really well established in Fourth Amendment case law that you have a right to refuse to consent to searches and to say you need a warrant to do that? We protect people from making those statements in encounters with the police, right? So I don't understand how this factors in at all, the fact that it says you need a warrant for my trunk. What from that gives rise to any reasonable suspicion, much less probable cause? I just don't understand that point in your argument.
So I agree that the right to not have your trunk searched is certainly true, and the fact that he kept asking the question and kept repeating that he didn't want him to go into the trunk, coupled with his behavior. He was becoming increasingly nervous and anxious, and calling friends. He called multiple people. He asked somebody if their mom could come. So all of that, to me, says that he knows what's in the trunk. I mean, not even considering the fact that he did go on to say, it is what it is, you're going to find it. I'm not trying to, beat anything. I forget the exact phrasing.
He said there's something. Right.
Yes.
He said there's something there, which is probably true of most trunks. And he said it is what it is. And he was arguably nervous. And that's it, I think.
Correct. I think saying that there's something there is evasive, other than saying what is actually there. And the fact that he had already identified the weed and he wasn't going to say what this specifically was, it's evasive enough to give rise that there might be something incriminating in the trunk.
Yeah. And that's enough for probable cause?
I'm not talking about probable cause here. I'm just talking about the
Talking about the decision
search.
to change away from, to say it's not going to be an inventory search anymore. What decision point are you addressing here, right? He was initially, the officer said, well, it's a reasonable alternative to have your friend come get the car, and then he changes his mind on that. And so this is the basis for kind of changing your mind and saying it's not a reasonable alternative to have your friend come and get the car?
Right. Well, so it's our position that the defendant was already getting more than he was legally obligated to get when the officer agreed to let a friend come, because all the case law where they have given the car to somebody else, the passenger was already on scene at the time. So if we look at like Ellerby, in which there was a passenger on scene who was not able to take the car, and they held in Ellerby that an officer is not obligated to wait an indefinite amount of time for a third party to arrive.
Right. Can we conclude that the officer's initial agreement to the arrangement was an indication of its reasonableness?
Yes.
Okay. And then he changes his mind based on sort of this kind of investigative. He's trying to figure out. He's thinking that there actually is something there, right? So he has this kind of an investigative purpose that emerges during the encounter, right?
I would say that it's not investigative. He's actually responding to what the defendant is saying. The defendant is the first person who offered the comment about the trunk. So he was just responding to what the defendant was asking. The defendant asked, you can't search my trunk, you need a warrant, right? And that's when he started to get suspicious. And
right. So he develops a suspicion.
Right, but and I'm not trying to conflate that with reasonable suspicion. I'm just using the word suspicious as colloquially, I guess.
So it's interesting that the policy, the only factor it has for deciding whether to leave the property with someone is the probability of vandalism. I mean, that's what it says. A vehicle may be disposed in the manner authorized in paragraph 1 if there is a low probability of vandalism. So under the policy, is it appropriate to consider that there might be something in the trunk in deciding whether to turn over the car to a third person?
I believe in Oliveira they had 4 reasons why you could inventory and impound the car. So one being protecting the public from dangerous items, which I think is the strongest argument here. And then 2 being protect public safety, where the vehicle is parked creates a dangerous condition. So the vehicle was pulled over on a 2-lane road. It was blocking traffic. There's also the threat of theft or vandalism, which I think anytime a car is left on the side of the road, there is that threat. And then, of course, the vehicle's being parked on private property, which isn't relevant in this case. But I do think that the protecting the public from dangerous items and protecting public safety are applicable here.
So is asking questions about to try to uncover whether there's a danger to public safety or danger of theft or vandalism, to do with the vehicle, is that the same as having an investigatory purpose?
No, I don't think so. I would say that the concern about the trunk and what's inside of it just gave rise to the inference that something dangerous could be in there. And I think that the defendant's behavior is what caused the police officer to have that concern.
So what's the potential public safety risk from something in the locked trunk? I understand, like, if you have, it makes sense if you're going to have someone come and take the car over that you want to check to make sure there's no weapon available. But if something's in the trunk, there's no threat to the officers at the scene, right? I mean, they're not,
Well, it depends on what's in the trunk. If it's a gun, then yes, there's no threat to the officers on scene unless someone comes and opens the trunk, but we don't know yet what the contraband is, and we don't need to know what the status of the contraband is to say that there's something dangerous in there.
Well, why don't we? Most things, even illegal things in a trunk, aren't dangerous. I mean, it's probably not nitroglycerin that's in the trunk. So how reasonable it is to think, from what the defendant was saying, that there's something not just illegal but dangerous in the trunk?
Well, I believe that we need to look at it not in hindsight, but in what the officer was experiencing at that time. And while we could say now that it's probably not, you said nitroglycerin, right, in the trunk, we can't say that for sure. So I believe that the officer should be able to work within their own experience and their framework of what's happening in that moment.
And what's happening in the moment is the defendant saying, you need a warrant for my trunk, and there's something there, I'm not going to tell you what it is.
Yes.
And that's enough to give rise to a valid public safety concern that there's something.
Yes. And
the public safety concern is to who?
the public safety concern both to the people who are on the scene, and then if someone did arrive, a third party came and took the car, and we don't know what they are going to do with the dangerous item that's in the trunk.
So they could take the car, drive away, and then get the trunk, pop the trunk, and find the dangerous item there?
Correct.
That seems to open the door to a search in almost every case.
Perhaps. However, the inventory search here was valid because when he was pulled over and arrested, there's no obligation to wait for a third party. And when the inventory search was initiated, there was no third party on scene. So the police officer was completely within his rights to initiate that inventory search, even if the defendant hadn't said anything about the trunk.
Except for the fact that if there's a reasonable alternative to doing an inventory search, then you should allow that reasonable alternative, correct? And the officer thought there was a reasonable alternative and changed his mind once he got suspicious about what the defendant was saying.
I think that's one of the reasons that he changed his mind. It's not the only reason. It had also
What
been...
are the other reasons? Yeah.
Sure. So at the time that the defendant was making multiple phone calls, he did not know where he was. He asked someone's mom to come. It was not clear if anyone was going to come, and it wasn't clear if anyone did arrive, if they would even be able to take the car. So even if they come at some indefinite period of time, who knows how long it's going to take for them to then vet the person that comes. If only one person came, then they're going to have to figure out or brainstorm a way to get two cars off of the scene, because otherwise the person who comes in their car is going to have to leave their car. So there's really just no obligation for the police officer to do all of those things for the defendant who has been.
Right, but I mean, I watched the video, right?
Yeah.
I saw what happened, right? And clearly the officer was motivated by what the defendant was telling him and saying, you need a warrant for my trunk. That was what made the difference. It wasn't this kind of speculation about, gosh, maybe this won't work out, or, right? I mean, that was, the motivating factor was the defendant's comments. You need a warrant? Yes, there's something in there. It is what it is.
That's certainly what the officer testified to. However, because he was not asked if there was anything else, I can't speculate as to that being his only motivation.
But the officer tells the defendant that he can call someone, and there's someone within 10 minutes. So these factors that you're suggesting, aren't they inconsistent with what the officer did? If he was worried about someone coming in such a short period of time and then having to spend the time checking them out, wouldn't he have just said no in the first place?
He may have, and I still stress that it's within his right to make that discretionary decision, and that there is no case law that says you have to wait a certain amount of time. And if you decide to put it into a rule that they have to wait a certain amount of time and that it's 15 minutes, then perhaps he would not have been within his right. But I have not been able to find anything where there's a time or where it says once the officer has agreed that he can no longer rescind that agreement.
Did the assistant DA elicit any evidence from the officer about, we saw in the video that the officer examined the defendant's driver's license and his registration was on the front seat. Did any evidence come in about where the defendant lived? I know the warrant was out of New Bedford, the arrest warrant.
I'm not sure. I could look again at the,
But so if the assistant DA didn't ask the question, where did the defendant live? Then the amount of time, there's no
Certainly.
inference that the amount of time would have been greater or lesser.
no, although if he is far from home, there could be an inference that the majority of his contacts would be close to where he lives and therefore would take longer to get to the location. I'm not sure if the officer had that thought.
Do you think we can infer that the judge believed the officer? I only ask because the officer makes some statements about the timing he had been told that aren't in Judge Coffey's findings, and I'm wondering whether we can assume Judge Coffey generally found it credible.
The officer's testimony?
Yeah.
I'm not sure. I can't speculate on that.
Do you have any inventory search, automobile exception cases that involve trunks?
That involve trunks, excuse me. That involve trunks specifically, yes. Sorry. So I believe in Eggleston and Cabrera. In Eggleston, they held that there's probable cause when the car is on a public way and a prudent person would believe that there is contraband. And then in Cabrera, the presence of drugs can be considered collectively to give rise to probable cause. So both of those cases, I think, are analogous to this case, where the weed had been found and the car was parked on a public way.
All righty, anything else?
Nope. Any other questions, or else the Commonwealth rests on its brief?
All right, well, thank you. I noticed that you cited Commonwealth versus Horton in your brief. That was also argued by a Suffolk intern who went on to clerk for Justice Cowan and become a Middlesex ADA in appeals for 17 years now. So you stand in good stead. I hope you'll consider making a career of arguing here.
Thank you.
Thank you.
Thank you.
Thank you both. Second case is Commonwealth versus Henry, number 23P 1301. Just a sec. All right. Whenever you're ready.
Thank you. Good morning. May it please the court, Amy Cottignon on behalf of Mr. Christopher Henry. I'd like to address a couple of claims today, including the newly discovered evidence, the denial of pretrial discovery, as well as the speedy trial claim. But before I begin, I would like to ask that this court consider not just each individual claim, but really the cumulative effect of each of the claims on whether or not this conviction was just. Because I would suggest to the court that when looking at both what happened pre-trial, during trial, and post-conviction, where there's a bunch of different information that's come to light since, that the sum total of this makes this an unfair and unjust conviction, and I would ask that this court reverse or remand for an evidentiary hearing. First, I'd like to address the newly discovered evidence, which I would suggest calls into question the justice of Mr. Henry's conviction. Beginning with the new percipient eyewitness, Mr. Townsend, I'm asking that this court grant Mr. Henry a new trial because Mr. Townsend's his testimony both corroborates Mr. Henry's otherwise uncorroborated testimony, but also contradicts the sole witness who testified for the Commonwealth as to what happened in these events. I would suggest that it meets the standard set by Grace and the other cases. It carries a measure of support in Mr. Henry's position. but it also contradicts the Commonwealth's theory of the case. So Mr. Townsend, as the court is well aware, testifies that Mr. Henry, or would testify, had an evidentiary hearing been granted, that Mr. Henry was not the first aggressor here, that he was hit first. He testifies that Mr. Henry didn't have a weapon.
So I was wondering about that,
Sure.
because I looked at the video, I think we all have, and Townsend is quite a distance from your client, and the knife is, the razor or whatever it is mostly hidden in the hands, according to the testimony. How could you see it from across that distance?
Well, I think there's two pieces that I'd like to say to that. As to the distance, I think you can see whether or not his hand is in a fist, or how he's holding his hand. You can see the motion that he would be making. If it's actually a slashing motion from top to bottom, he would have seen that from that distance, from across the tier. But beyond that, the other sort of piece of this is...
But he doesn't say in his affidavit he didn't see him in a fist, didn't see a slashing motion, just says, I do not recall, I did not see Henry with anything in his hands.
Right, and he sees punching, mutual punching.
Yeah.
It
sounds like
so I
it
would
did
suggest
see a
that that's
fist.
and again, these are questions for an evidentiary hearing, right? That could have been further developed in the record had the court granted an evidentiary hearing. But the other sort of piece of this is that the idea that this is a small secreted razor blade in Mr. Henry's hand comes from the sole eyewitness, who originally, in his police report, says it was a sharpened instrument. A razor blade is not a sharpened instrument, it's already a sharp instrument. And he says that it was, in his fist. He also says that he was 3 feet away from the altercation. But Mr. Townsend says there was nobody 3 feet away from the altercation. There was nobody on the top tier at all. The correctional officers were all down below, and they came running up once the fight began. So really, the idea that it's a small weapon, that it's secreted in his fingers, all of that comes from that sole witness whose credibility the case depends on, and who Mr. Townsend contradicts. And so in a couple of different ways, I would suggest that his testimony contradicts that in terms of, first of all, who the first aggressor is, right? According to the correctional officer says that all that he sees is one swing coming from Mr. Henry, which is that sort of diagonal across the face swing. That's not what Mr. Townsend says at all. And so, this sort of series of events, it would certainly be something that a fact finder would deliberate. Who do we believe? Do we believe Mr. Henry, who's now corroborated by this third party where we don't have a victim, we don't have a single other eyewitness, and we have a correctional officer who admits on cross-examination that he doesn't remember certain things. We have a video that's panning across the top tier, and he's not there, despite that he says he's doing rounds. And then again, we have the unit logs, which is information that was uncovered post-conviction.
Could you walk me through those logs, because I read them and I didn't really understand what I'm supposed to take from I understand the entering from property thing, but
Yes.
But the rounds logs, I'm not sure what I'm supposed to take from that.
I think what I would ask the court to take from that is that if you look through the logs, they are documenting when the rounds are taking place. And at and around the time of this fight, rounds are not taking place. They had taken place, and I apologize, I don't have the specific time, but I think it's about an hour earlier. So the rounds are not ongoing. And what I think that the court can take from that is that the correctional officer says, I was on the top tier because I was doing rounds. That is why I was in an opportunity to view this fight when it began.
GSW and GNW is?
I don't know. And again, that's why I was advocating here for an evidentiary hearing, because we could have somebody come in and interpret these logs. How long does a round take? How closely are these documented? Those types of things, I think, are certainly able to be explored at an evidentiary hearing, but I don't know what the documentation, or the acronyms mean. And all of this, I would suggest, ties into the discovery. The Rule 17 motion that was denied pre-trial, where counsel was looking for the identity of witnesses, looking for maps of the unit, all of those things. Because had that discovery motion been allowed, we would have known of Mr. Townsend. We would have had the unit map. We would have known where these cells were in relation to one another. We would have known if there were other eyewitnesses who may have seen this. Because if you look at the video, and I know this court has, you can see that there's probably, I would estimate, 24 people that are looking up at this fight. There's other people, across the tier who are watching this altercation. And those people are percipient eyewitnesses. And if we take this out of a jail, if this had happened, on the stage at a play or somewhere else, and there's a roster of who was there, I would suggest that in any other circumstance, the defendant would be entitled to the identity of
There's no roster of who was there, right?
Well,
you could find out who lived there.
Yes.
But you couldn't have a roster of who was sitting. There's no suggestion there's a document that lists who was there at the time.
There isn't, but there is certainly documentation as to who was there and also which correctional officers were staffed on unit that day.
When you say, now again said there, you mean like live there?
Live there, live on the unit, yes.
Is there any evidence that people within that there were other people who, jail units have defined populations, and I take it that you assume that there's probably a document listing who was there on a particular day. Is there any evidence whether or not there were other people there, other inmates there who weren't assigned to that unit on that day, or was the list of potential witnesses limited to the actual inmate population and the COs, of course, but the actual inmate population of the unit?
So I would assume that, as I understand it with jails, the only people that are allowed on a unit are people that live and reside on that unit. So any documentation that lists who is living and residing on that unit would encompass the people that were there that day. However, and I don't know that a list itself exists, right? But what I do know is that when we sought this information post-conviction to confirm that Mr. Townsend did in fact live on that unit, we were able to get documentation, redacted documentation, but documentation nonetheless, that what his name is, date of birth, all of that information, and his housing unit assignment at the time. So if a list didn't exist, in my reply brief, I make an argument relative to, if there was some privacy or other concern, the jail could have made such a list so as to not, have to turn over all of the, housing lists of every single individual inmate. They could have certainly created a list if that were easier for them. And I think that the case law supports that where the record holder has the information, they can be required to produce it in such a way. And so I think that, when we're looking at the standard for pretrial discovery here, Mr. Henry meets that, because it's not speculation to believe that there are people on the unit. We know there are people on the unit. We see in a video that there are people there, that people are observing this incident, right? We know there are percipient witnesses out there, many of them. And he has no other way of getting that. And I think that that's supported by counsel, who says, I couldn't find anybody. I couldn't find the victim. I couldn't find the other individuals who attacked this man directly thereafter. After this happens, again, tying into the speedy trial argument, we can't find anybody. So the ability to have the names to be able to investigate and talk to people who were on the scene to determine who might have seen this and what they saw. Were the correctional officers down below, or were they upstairs like they said? Are they actually 3 feet away, or are they, down below at the desk? These are important questions, and I think they raise a reasonable doubt in the minds of jurors if you can find an eyewitness who has seen this. And we know, based on that video, that there are dozens of people that did, and we know that Michael Townsend, who's uncovered post-conviction, would have been a person whose name would have been on that list. It would have been somebody that counsel would have investigated. He says so in his affidavit. It's somebody that he would have presented at trial. So I would suggest that Mr. Henry amply met that standard, and that for that reason alone, reversal of his conviction and remand for a new trial would be warranted. If I could touch just briefly on the speedy trial claim, this is an instance, as the court's aware, that happens in a jail. Mr. Henry's unaware that a complaint has been filed in 2015. He learns of it in 2017, and in 2017 he begins pretty diligently trying to assert his right to come to court. He writes letters, he cites the due process clause, he has attorneys writing letters, he seeks a HABE, and the Commonwealth makes no effort to bring him before the court. And in fact, we have records from the Bureau of Prisons where the Commonwealth knows that he is in custody and says, we're going to wait until he wraps his sentence before we ask for him to be brought in. And they, in fact, do that. There's no effort to bring him before the court until 2018 when he is indicted. And that's nearly 3 years later that he's brought before the court. The motion judge made, sort of a bigger deal in this finding that Mr. Henry had cut off his GPS, and he weighs a period of a couple of months against Mr. Henry. And I just want to point out to the court, I can find nowhere in the record where there's evidence that Mr. Henry cut off his GPS. There is evidence in the record that he wasn't in default for a period of time, I think 3 months. But that is the only period of time that I would advocate could be attributable to him, against him in a speedy trial analysis. For the remainder of the time, he is sort of diligently pursuing this case. He is seeking discovery, filing motions, doing what you would expect a defendant to do. And really, there's a period of 2.5 years, which in and of itself is problematic, where the Commonwealth makes no effort to bring him to court to answer on these charges. In each of the categories, the assertion of the right, the length of the delay, the reason for delay, and the prejudice to Henry, the motion judge seems to find that they at least weigh slightly in Mr. Henry's favor, but yet he denies, he says that the claim would have been denied. And I would ask that this court de novo review that analysis again. And in making those same conclusions, I would suggest that there is certainly a federal constitutional and state constitutional speedy trial claim there. With regard to the prejudice prong, I would also advocate that the court did not correctly apply the law. The court found that there was no oppressive pretrial incarceration for Mr. Henry as to this claim. And one of the things that I think that the motion judge here missed is the idea that Mr. Henry was held in custody for a number of years before he was brought to trial on this case. That would have been, an opportunity for him to seek concurrent time. He wouldn't have had 2 periods of detention. He wouldn't have had to serve the sentence and then be held on bail on this case pending a trial for 1.5 years. Had they run at the same time, had the Commonwealth made that effort to bring him before the court. He could have advocated at the end of a trial for concurrent time. And so despite that the first period of incarceration wasn't on this case, it is oppressive because they sort of stacked the periods of incarceration. The other thing is that the Barker case from the United States Supreme Court, and I quote, says, if witnesses die or disappear during a delay, the prejudice is obvious. Here, every witness who is identified by the records that we have disappeared. So the court found that there was no prejudice, but that is, it's sort of textbook prejudice. We have this sort of delay of justice, this delay of the ability to advocate for himself, to investigate, to speak to anybody who may have seen what happened here. And I would suggest that the prejudice here to Mr. Henry is significant, and the anxiety, if you read his letters to the court, is significant. He's saying, I want to fight these charges. Bring me to court, please. And nothing is being done. And so I would suggest to the court that the failure to litigate that speedy trial claim is ineffective assistance of counsel, because where those 4 prongs weigh in favor of Mr. Henry, the motion would have been allowed. The failure to litigate a dispositive motion, that would have resulted in the dismissal of a case is
Can I ask you about the search policy?
Sure.
Because it's a June 2021 search policy. So I don't understand why it has any relevance at all, because it didn't exist at the time of this incident.
Sure. So,
Missing.
yeah, and I think, again, at an evidentiary hearing, we could have probably called in a correctional officer to talk about, and that was what I had asked the court for, the opportunity to call an officer to talk about what searches happen when somebody's coming in and out of the unit, right, to tie that into what would have happened with Mr. Henry. Because the search policy is in some ways sort of vague. It doesn't talk about, is it going to be a strip search or is it going to be a pat frisk? Is legal storage, which category does that fall
under? But more importantly, it didn't exist at all.
Well, I'm sure that some search policy existed at the time. I don't think that the Plymouth County House of Correction would have gone without a search policy for people entering and exiting. I see the court's point that the search policy is dated the time that I obtained it, not dated the time of the incident. But I do think that at an evidentiary hearing, that information could have been developed in terms of what would have been happening in the unit on that time.
I have a question for you about the record as far as Judge Sullivan's findings about your client cutting off the GPS. The docket shows that on April 11th, 2018, GPS was set as a condition of bail. I'm assuming that Judge Sullivan had access to the records of the Department of Probation concerning when GPS was put on your client, or if it was put on his release. Do we have those records in the appellate record before us?
I don't believe so, Your Honor. I don't believe so. The probation records are not part of the record. There is a motion to revise and revoke that the Commonwealth included within their record appendix. That just says that he had picked up a new offense.
So if Judge Sullivan is making a finding based on the probation records and neither party has given us anything that contradicts his finding that the GPS was cut off,
I don't know that a probation record would show that a GPS was cut off.
it would show it was put on.
It certainly would show it was put on, but if he was arrested on a new offense out of Boston and then held in custody on that new offense, the GPS would have been taken off for him to be held in custody. So I don't know exactly what happened with the GPS. but I do know that there's nothing in the docket or insofar as I know in the trial court record that shows that that's what happened. So
Not in the trial court record, and we don't know about the probation department record.
we don't know, and the court doesn't say that he relied on probation. I never heard the court ask for the probation file, so I don't know.
Let me try it this way. The prosecutor said at the trial, after sentence or around sentencing, that this is what happened, that he cut off the GPS bracelet. And when we're talking about a speedy trial question, why wasn't the judge allowed to assume that the Commonwealth could prove this at an evidentiary hearing?
He could, but I think that the point that I was trying to make was that was a period of weeks in a 4 year, some month span, a period of weeks, when the rest of the time he's sending in letters, advocating to come to court, all of those things, and then when he is in custody, he sort of diligently pursues the case. He seeks discovery. He, schedules a trial date. So even if that period weighs against him, I'm not necessarily disputing that it does, but it's a period of weeks in a long span of time.
I get that. All right.
The remaining issues, I would rest on my brief. Thank you very much.
Thank you very much. We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth, standing in for ADA Johanna Black, who submitted the brief in this particular matter. In looking at the speedy trial issue that was just being discussed, in denying the motion for new trial, the judge was not only looking at that period of time in regards to the GPS being cut off, he was also looking at multiple dates that were either agreed upon continuances, unobjected to continuances, or continuances at the defendant's request. There was also a trial date, I believe in December of 2018, where it was the defendant who, on that day, the day of trial, decided he no longer wanted particular counsel that he had and wanted a new attorney, and that then moved things further back. So,
well, Counselor, I mean, once the indictment happens, things move reasonably fast, and to the extent they don't do, it's because of the defendant. But you still have 13 and a half months between the federal sentence being imposed and the defendant even learning about the charges, where it would have been really easy to find him because he was a federal pretrial detainee, so you know exactly where he's most, how to find him. I mean, how do you explain that gap of time?
there is no explanation for that. It's clear in the record, it was clear in the judge's findings that it was negligent on behalf of the Commonwealth, and I don't have anything to put forward to dispute that. I don't know why that happened, to be quite frank with all of you. But that is something that the judge acknowledged, said that that did weigh against the Commonwealth. I don't think that that was a secret or was pushed aside, but he also found that it was negligent. It wasn't a purposeful sort of wrongdoing to in some way harm the defendant. It was negligent. It was weighed, and then it was weighed against all of the other factors. In regards to the Rule 17 motion, because I know that that is of concern as well, it's the Commonwealth's position that this was very speculative, and it was, as you could see from the Sheriff's Department objection, this was, quite frankly, being used as a discovery tool, which is not allowed by Lampron and Dwyer. The searching that there might be witnesses, there might be information, there might be something that's helpful is not what the Rule 17 Lampron-Dwyer protocol calls for. It's meant for records, documentation that's likely admissible at trial. There has to be some showing that it is actually relevant and is not a tool to gather information. That is not what it is designed for, what the protocol allows. And if this incident, say, had happened at, say, an apartment complex, Are we opening the door to then say now that the defendant should now have access to every single tenant's information because they're in the area and they might have seen something that happened?
The difference, or one of the differences, that in a jail environment, the government controls who's in the area. They are responsible for the custody of inmates, and therefore they know who's in a particular unit. And here, the defense was, the potential defense was, this incident didn't happen the way the correctional officer said it did. Why wouldn't it be critical to identify and interview witnesses who might corroborate the defendant's account of how the encounter happened?
Because there's still privacy concerns. Just because they're an inmate doesn't mean they have no privacy concern just because they're in.
A privacy objection to giving this information, to disclose the names of inmates, potential witnesses, it's a privacy
Well,
objection?
my understanding in looking at the motions and looking at the opposition, if I recall correctly, was that they were asking for more than just that. They were asking there would be Corey information. There was a lot more to it than just simply who they were.
Right, okay, so maybe they're asking for information that's not Corey available, maybe there's some issue, but the core of the request is, I'd like to know the names of all the potential witnesses who might have seen this incident happen. And so maybe the jail doesn't have to disclose their birth dates or other identifying information, but why wouldn't the jail, since it certainly has an information gathered, because that's what jails do, they control environments, why wouldn't they at least say, here is a list of potential witnesses, take this information, do what you want to explore your defense?
For two reasons. One, that is not what Rule 17 Lamprey-Dwyer is designed for. That's a discovery tool. That's a mechanism. And secondly, the same argument then could be said for what if this was in a hospital setting? You're controlling the environment. You have the list of all of the patient names. You're not giving out any other info. You just want to get all of the patient names. Would that be okay? Would that be allowed? Or is it only because they happen to be inmates that it's okay to give out all of their names, every single person that was there, based on the speculation that they might have relevant information, might have seen something that is helpful to the defendant?
Well, this is a discrete incident. The inmate said the defendant said it happened one way. The officer said it happened a different way. It seems very pertinent to find out who else saw this incident. What do they say? And the defendant's not able to find out any of those people, those potential witnesses, because the jail refuses to give this kind of basic information about who was there. And you're saying that's not covered by Rule 17?
The jail was not refusing to give basic information. They did provide, the judge found that some of the Rule 17 motion was allowed and or already provided.
Right, but they're not identifying potential witnesses to the offense.
Right, because that goes on. The Rule 17 doesn't mean you have to create discovery or create information or go back and create and formulate a list. That's not.
You don't think a jail has a list of inmates on a unit at any particular time? You don't think that's an existing document anywhere?
They do, but but again, you're asking for a list of every single person that was there. If you look at that video, there were inmates that had their back turned. There were inmates presumably that were in cells and wouldn't have been able to see anything. You would have their information as well if you're only giving a list. It's not, there's no way to then differentiate this was someone who was sitting within eye view, or this was someone who was in their cell going to the bathroom and couldn't see anything.
Quite clearly, defense counsel would have to go talk to these people and find out what they saw or what they didn't see. And counsel eventually did find a witness, and he seemed to have evidence that was helpful to his position and contradictory of what the correctional officer testified. So why isn't that allowed as a matter of basic due process, to allow a defendant to identify potential witnesses to an offense and interview them and find out what their information, does it support my case, or does it corroborate the Commonwealth's case?
Again, it goes back to if it's speculation and then it's basically saying they're going to be entitled to a list of everyone who was there simply because we have that information. And if it's allowed in a jail setting where it's controlled, it would then happen every single time there's an incident in the jail. That every single inmate's the name of every single inmate that's on a unit would then, if we're following that line, it would happen anytime there's an incident in the jail, whether or not they were actually involved, whether they actually saw anything.
I don't know why that's bad, though. I mean, if a system where if defense counsel wants, he can find out who was housed in any unit where a crime happens, why is that bad? You seem to be suggesting that's bad, that would be a bad system, but I don't know why that's bad.
Well, if we're talking about we're talking about using Rule 17 as a mechanism to get that.
I get why it might not be allowed by Rule 17, but you're also suggesting beyond that it's affirmatively bad, and I don't understand why.
I'm not saying necessarily affirmatively bad, I'm saying it's speculative, and then at what point does that end? In what scenario is it allowed or not allowed? And that's where I think the concern is, as far as it's allowed only in jail setting, but not in a hospital setting, not in a school setting. If an incident happens in a school, should defense counsel then get the names of every single student in a particular grade, in a particular school? Because they might have information. I guess that's what I'm questioning as the concern. I'm not saying it's affirmatively bad. Obviously, you would want to know who was there and witnessed, but to have this blanket, just sort of here's everybody's information just because they happen to be there, at what point would that end?
Could defense counsel have used the list of names to say to the investigating corrections officers, well, did you interview so-and-so? Did you interview so-and-so? To raise a Bowden defense, essentially. So you're distinguishing between Rule 17 and Rule 14. Mm-hmm. But assuming that it's not appropriate to get this under Rule 17, mm-hmm. can't the defense say, use this list to show that the Commonwealth's investigation wasn't thorough, that there were witnesses they didn't interview?
Yes. They could, but again, it would be requiring law enforcement, whether you're in a jail or in some other setting, to then provide lists of everyone that happens to be there or happens to be
nearby.
And that is not generally not how, that's generally not required in any other situation that I'm aware of in order for an investigation to be thorough or considered thorough and valid.
If there was something like gang involvement or reason to believe that some inmates were afraid to come forward or didn't want to be involved, the prosecution could move for protective order under Rule 14 on the discovery.
Yes. Yes, there could be a protective order, particularly in the documentation from the prison. Generally will have a list of individuals that are known quote-unquote enemies or people that have had issues with each other in the past. They would be listed on that inmate's information. So that would be something that counsel would have, presumably, if they have the information, the intake packet for the inmate.
Can you address the judge's reasoning for discrediting the affidavit from Mr. Townsend? It seemed to be his main point was, well, this is contradicted by the officer's testimony, and therefore I'm going to discredit it. But wasn't the whole purpose of the affidavit to show that another witness, a disinterested witness, had observations that supported the defendant's account and not the correctional officers?
True. I think he did make that comment, but I think in looking at the affidavit, he also talked about how far away Mr. Townsend was, and I think in the affidavit, he talks about being, so I don't want to misspeak, he talks about being directly across the tier from them. So he talks about a distance, but he doesn't quantify that. And I think that's something that the judge pointed out is, there's trial testimony with someone who's a few feet away. That testimony was credited by the trial judge, and now you're getting an affidavit from someone who's like, I was some distance away and I didn't see a weapon.
Well, Mr. Townsend gave a very precise account as to where he was in
Yes.
relation to the tier. It's true, he did not give the actual footage between him, but he said, here's what I was standing, here's what I could see across the tier. We could probably go and measure that tier now and figure out the exact amount of footage that correlates with his testimony. So the fact that he didn't give a precise amount of distance doesn't seem to be enough to sort of say, well, this is not a helpful affidavit. There was a distance away, and it's true that the guard said he was 3 feet away, but that seemed to be contradicted by what Mr. Townsend said and what the defendant said. So I just don't quite understand that point as a basis for saying this affidavit is not pertinent.
Yeah, I think, not to speak for the judge, but I think, though, he wasn't saying that that was the only factor. I think he was looking at how speculative this information was, the distance, the fact that, quite frankly, the defendant's own testimony didn't seem to exactly fit with what Mr. Townsend was saying as far as whether they were in a cell or not in a cell when it took place. So I think it was multiple factors, though he did cite that. I don't think it was the only reason why he made the decision that this was not, again, in honoring sort of the finality of verdicts, that this was too speculative to then grant the new trial. And I see that I'm about out of time. If there are no further questions, the Commonwealth would rest on its brief.
All right. Thank you very much.
So much.
It's a complicated case. It was well argued and well briefed. Thank you very much. We'll move on to the third case, Commonwealth versus Teixeira, 20P832. I hope.
May it please the court, I'll go ahead and start with the first argument.
Mr. Benning, can you just wait a second, let your friend get say. Okay, great.
I'll spend my time talking about the first argument of sufficiency. I understand the indecent assault and battery convictions, but it's this one that is giving me trouble, and hopefully you too, or if not, hopefully by the time I finish speaking, it will give you pause. I guess I'll start by saying that if we look at the statute, it says assault with intent to rape. It's not an indecent assault with intent to rape. And I'll just quote from Commonwealth versus PLC. This is in my brief on page 28. An attempt is an act which is intended to bring about the substantive crime which sets forth in motion natural forces that would bring it about in the expected course of events. The leap here is that an indecent assault and battery carries with it implicitly an intent to rape, which I don't think it does. I think that's actually harmful to the law, and this case kind of shows why. If you look at the facts, yes, there are indecent assaults and batteries. However, at no point can it be said that there is an act that shows his intent is to rape. Go ahead.
The victim testified that the defendant tried to put his penis in her mouth. Is that not an intent to commit rape?
Yes, that is true, but he didn't. And it's also more on the neck and the face and the cheek.
She moved her head.
Yes, she did.
So an attempt can be an attempted battery or an immediately threatened battery.
Yeah.
Why wasn't it one of those?
So this keeps in line with the charges, again, which I'm not I'm not fighting against the indecent assaults and batteries. But in this case, if you look at the context of the case as a whole, while he does touch her breasts and kiss them, he does not undress her. He does not remove her skirt. He touches her but keeps it above the pubic area. And so it looks like his intent is to just merely indecently assault. In other words, there's nothing about his penis on her cheek that necessarily conveys penetration. Again, if we're looking at what proof is beyond a reasonable doubt, that is supposed to be a sufficiently high standard so as to prevent the government from improperly incarcerating or taking a citizen's liberty interest.
So the question really is there enough evidence to establish that there was an attempt to penetrate her mouth? When you
Yes,
say that's, and
that's
you're saying,
essentially-
you do say it doesn't quite rise to that level. That's your kind of position.
That is my argument.
Okay.
That's right.
Appreciate it.
The trouble here is, my concern here is if you look at what the statute was intended to penalize, it doesn't seem like this really raises that standard. If you look at the statute, it gives basically up to life in prison for attempted to rape. I'm sure you've read as many transcripts as I have, if not more. This is fairly mild by the set of circumstances that I've read, and I've never seen a...
Why is this mild? He tries to orally rape her, a friend of his daughter's.
So again, mild in the sense of what I've read in transcripts, and I'm sure you've read with respect to child rape. This is... especially when initially he was given up to 15 years in prison. The difficulty here is when you give these sets of facts to a juror or a jury, there's always an attempt, I think, by the Commonwealth, or there's always a fear that the jury will convict based on not beyond a reasonable doubt, which is supposed to be a very high standard, but more just out of a desire to get the person, to convict the person. That's my concern. Now, I understand that the appellate division did lower the sentence. It lowered it to what would be more appropriate to indecent assault and battery, because that's really what this case boils down to. Are there any questions with respect to that?
Hey, well, I have a question about your argument that him saying, I won't take your virginity, shows a lack of intent to rape. If somebody walked into a bank with a gun and said, I don't want to hurt you, would that negate the assault?
I'm not fighting the assault and the indecent assaults and batteries, but again, what we're talking about is something that puts in motion the attempted rape. So that comment specifically, that I won't take your virginity, yeah, I mean, in a context you can say, okay, maybe that shows that he has an intent or had an intent to rape her and now he's changed his mind, or it could just show that he is acquiescing to, you know, whatever she says in an effort to get her to perform, you know, whatever act on him that's not penetration. And so, and I understand that, you know, you have these distinctions, you send them to the jury, but again, your job is to look at sufficiency. Otherwise, I mean, that's one of the things that this court is required to do, to see that the statute is enforced and that every element is proven beyond a reasonable doubt. Again, beyond a reasonable doubt is a very high standard, and it should be. It should be. Again, this case I feel is overcharged simply because, yes, indecent assault and battery occurred, but an assault with intent to rape didn't. It doesn't rise to the level that would require life in prison. In fact, again, the sentence was reduced.
I have a question for you about the specific unanimity instruction argument. So the judge instructed, and this is a transcript 5, page 127, so you have a separate verdict slip for each of these alleged crimes, and again, the indecent assault and battery verdict slips are labeled as to the specific act that is charged. Your verdict has to be unanimous, and it has to be unanimous whether your verdict is guilty or not guilty. Why isn't that a specific unanimity instruction?
You mean along with the verdict slips that kind of together? Because the purpose of a specific unanimity instruction is to call to the jury's attention the fact that each separate event or crime, and here, I go to my brief.
Is it that the acts weren't specified on the indictments, so it doesn't suffice to specify them on the verdict slips? Is that your argument?
No, I don't think that. But I think when you, because it's assault, here, let me go to the verdict slips. My client feels that if the jury isn't,
55 to 58, if you're looking for them?
Yep.
In the appendix.
So, rubbing genitals on the backside, I think, is general enough. So, for example, what occurs in the bathroom versus what occurs in the entrance foyer of the apartment can show that it's, I mean, even though you say, rub genital, it could be confused one with the other. So a specific unanimity is supposed to say to the jury, you're supposed to find this specific crime. In other words, half of you can't think it took place in the foyer, half of you can't think it took place in the bathroom. It has to be unanimous as to the event.
Why, if we allow diverse dates indictments?
Well, date is not an element of the crime.
But it sounds like you're saying time is, or room is.
I'm saying what is?
Room, like, so if half the jurors believe that he rubbed his clothed genitals on her backside
In the bathroom.
in the bathroom, and the other half believed it happened in the living room,
Without clothes, yeah.
then that's not, you're saying that's not specifically
That's not specific
unanimous.
enough. That's the point of a specific unanimity instruction, is to prevent the juror from dividing up as to what the elements, or not where it occurred, but the specific crime. In this case, we would differentiate them not through time, but through space, bathroom, entryway. Because, again, unanimity is important. It's one of those protections that prevents the government from removing a citizen's liberty interest easily. And so the jury has to be unanimous.
If that had said rubbing genitals on backside in bathroom, it would have been
That's
okay?
specific. That's much more specific, yeah. Again, there was anything with respect to that, so that's a substantial risk of a miscarriage of justice. But again, because we're talking about a defendant's liberty interest, where there were multiple assaults, indecent assaults and batteries, more than those that were charged, specific unanimity instruction is a good issue. Courts have, appeals court, this court has also, when it does actually publish something on this, it always admonishes trial court judges it's always better to give a unanimity instruction, although the transcripts that I see rarely do so. It's almost always up to trial counsel, if he's on the ball, that these unanimity instructions get brought up. Are there any other questions with respect to the second issue or with the brief? If not, thank you.
Thank you very much. Hear from the Commonwealth now.
Morning. Members of the panel, may it please the court, Assistant District Attorney Jennifer Thompson for the Bristol District. So to address the defendant's first claim on the assault to rape a child charge, there was no error in the court's denial of the motion for a required finding of not guilty on that count. Applying the Lattimore standard, any rational jury could find
that the Commonwealth met all the elements of that offense, and specifically the intent to have the victim perform oral sex on him. The testimony was clear from the victim, who was 13 at the time she spent the night over at the defendant's house, that when she was there alone with the defendant attempted to, she described, tried to put his penis in her mouth, and in so doing, she moved her head, and he resulted in rubbing his penis on her face, cheeks, and neck. That alone is enough to sustain a verdict of guilty for an assault with intent to rape, meaning the oral penetration of the victim with the defendant's penis. But in addition to that testimony, we have other factors here. She testified that she had spent the night over at the defendant's home. She didn't know the defendant, but she knew his stepson. When the stepson left her alone with the defendant, when the family had gone to church, the defendant...
Son, yes. I said daughter earlier. I just got confused.
Yes. So when she was alone with the defendant, he immediately proceeded to sexually assault her in different ways. She described him as rubbing his penis against her buttocks, kissing her neck. When she moved from the bathroom into the kitchen area, he proceeded to continually kiss her neck despite her protests. He then got her into the living room, where he took off or pulled up her shirt, pulled down her bra, kissed her breast, used his mouth on her breast, and at that time tried to place his hand down her pants, at which time she said, "I don't want to be doing any of this, I'm a virgin." At that time, he said, "Well, we can do other things instead." Prior to any of his assaults, he also mentioned the fact that, "Why are you messing with my stepson? You should mess with me instead." Essentially, older men or younger women are good for older men. So we have comments of a sexual nature to the victim, as well as sexual advances prior to his attempt to penetrate her mouth with his penis. So based on those facts, as well as her testimony that he actually tried to do this, the reasonable inference was that he, in fact, tried to orally rape her. And I cited Walker, Leghens, and Bratman in my brief, which were similar in the fact that this court noted that the combination of the sexual advances and the sexual comments was sufficient evidence of intent to rape. So based on those factors, the Commonwealth did prove beyond a reasonable doubt, and it was enough to go to the jury on that issue, whether the defendant intended to effectuate an oral rape. So Bratman is actually very similar to this case, except Bratman involved an adult victim. But in Bratman, the victim was unknown to the defendant. He brought her into his apartment. She was alone with him. They were sitting on the couch. He pushed her down by her shoulders after making a comment to her that she was attractive. At that time, he put his hand up her shirt, felt her breasts, reached for his belt in order to take his belt off and pants off. At that time, the victim in Bratman said, "I don't believe in premarital sex." And at that time, the defendant abandoned his attempts to engage in sexual intercourse with the victim. In the court in Bratman indicated that, again, there was enough to infer that the defendant intended to have sexual intercourse against the victim's will in that case, based on the sexual nature of the advances in the struggle with the victim. And here, our victim did actually try to evade the penetration. There were sexual advances and comments as well. It's also similar to Walker, in which I cited also in my brief. And Walker was an incident which involved two co-defendants that had expressed their desire to engage in oral sex with the victim prior to sexually assaulting the victim. And at that time, one of the defendants had straddled the victim, pulled out his penis, and attempted to place his penis in the struggling victim's mouth. And again, the court found that there was enough to infer that the defendant intended to rape the victim. And again, it's very similar to the case at bar here. If the court agrees with the defendant's contention that there was a reasonable inference that the defendant only intended to indecently assault and batter the victim versus assault or rape, that would essentially mean that the Commonwealth would be precluded from charging someone with intent to rape as well as an indecent assault and battery. And that's a result the court, in this court in Oliveira, declined to implement. The court in Oliveira indicated that there was no reason to disregard an indecent assault and battery simply because there was also a charge with an assault to rape a victim stemming from the same set of circumstances, the same incident. And in this case, there's no reason to disregard an assault to rape charge simply because the defendant indecently assaulted the victim in the same vein. And neither, it suggests, is necessary for the other. There's no indecent touching required for an assault to rape charge. So the argument related to the defendant, we could prove neither indecent assault and battery or assault to rape based on reasonable inferences.
You don't need a touching at all for an assault with intent to rape, right?
Correct, Your Honor. So that it's not a lesser included offense. So we could charge both, but applying the defendant's reasoning, it would preclude the Commonwealth from proceeding on both counts, and that's not legally accurate here.
Can I get your thoughts on the second issue that the defendant raises about the 4 counts of indecent assault and battery? And I understand that there can be separate counts if the alleged actions are not incidental and necessary to each other. But you also acknowledge that this was essentially one episode. So I guess, could the Commonwealth, would it have been possible to have charged all of these acts in one count? Would that have been possible?
It would have been possible, and then that would require the specific unanimity instruction at the end. So yes, we could have charged, but this is very offensive. This is a 13-year-old girl. The defendant assaulted her in a number of ways, touching her pubic area, rubbing his penis against her backside, trying to get his, kissing her breasts, and also ejaculating on her. So
what is the purpose of chopping it all up and separating into 4 different acts? I mean, there's always a concern, right, that you're going to have maybe duplicative punishment or maybe jury confusion by doing that. So you say, because you would have to have a specific unanimity instruction in that case, that's sort of the logistical hurdle that's posed by that approach?
I don't think the logistical hurdle would factor into that decision. I think the decision to charge multiple indecents are based on the facts, and the facts, how egregious they are. Yeah. And essentially someone that assaults a child in several different ways, serious ways, would be treated the same as someone that maybe touched someone's buttocks. It offers more of a punishment based on the egregious nature of the assault. So that's really why the Commonwealth would proceed on the 4 different counts of indecent assault and batteries. And additionally, if the jury was to find that the defendant was not guilty of 1 indecent assault and battery, there's also, well, actually the specific unanimity, if we charge them all, they could still find 1.
But what if you had a judge who refused to give or forgot to give a specific unanimity instruction and the indictment was charged in vaguely? The Commonwealth would basically be at the mercy of the judges remembering to give specific unanimity.
Yes, it would have to be requested, or the judge would have to sua sponte give that instruction. There would be a danger if that instruction wasn't given.
Most offices, when they indict something like this, the indictments say to wit, and you're kind of playing with fire here. This judge was on the ball, but that's a dangerous way to proceed.
Yes, and since 2015, we've changed the approach as our indictments do allege the specific acts. And
that's
here
good
it
to
was
hear.
saved. There's no request for bill of particulars, and generally a bill of particulars would cure that problem. So here there was that danger, but it was saved by, 1, the Commonwealth's closing argument, specifying each act in each indictment, the judge telling the jury each indictment related to each specific act in the verdict slips. So it was saved, in essence, by those factors. But without those factors, if we didn't specify on the verdict slips in that the jury wasn't instructed, we would be in danger of a reversal on those charges.
Anything else?
So we didn't discuss the duplicative convictions.
We don't have to, but if you'd like to.
I would just suggest that, again, they're different acts. No act was incidental and necessary for the accomplishment of the other. It's just that touching the buttocks with the defendant's penis wasn't necessary to the touching of her breast with his mouth. So there's no danger of duplicative punishments in this case. And given the fact that, again, everything was specified in the closing and the judge's instructions, there was no danger of duplicative sentences, and they're permissible here, even though it's the same statute. The third argument.
Was that a specific unanimity instruction that the judge gave, or was there something more the judge should have said? The one I read.
It was a general unanimity instruction, but it was specified by the indictments itself. So it wasn't a word-for-word specific unanimity instruction, but I think the effect was the same based on the indictment. So here, the specific unanimity.
Based on the verdict slips, you mean?
Yes, I'm sorry. And here, the specific unanimity instruction wasn't required because this wasn't a case where the defendant was charged on diverse dates or was charged with multiple offenses in one indictment. So there was no specific unanimity instruction required here. And again, even if there was, it was saved by the fact that they were all specified during the course of the trial. And again, it would be a miscarriage of justice. There's no miscarriage of justice here because everything was cured by the closing, the instructions, and the verdict slips.
All right. Well, thank you very much. Ms. Thompson, I know you're a very experienced attorney, but my computer's telling me this is your first time here.
It is, Your Honor.
Well, welcome to the ranks of our appellate lawyers. I hope we'll see you more often. I think we will, actually. I think you've got a few more cases.
Thank you.
Thank you. Thank you both.
And I'd rest on my brief.
All rise. We're taking a break. 15 minutes. We'll be in a short recess. seated. Why don't you get noticed?
Thank you. All right, I will call the fourth case, Rao versus Sahakar. I'm not sure I got that right. 24P 130. Counselor, whenever you're ready.
Good morning. May it please the court. My name is Mark Swerbalis, and I represent the plaintiff appellant DURGAPRASAD Rao. Throughout the papers, I'm sure you saw that he's referred to as Durga. We have many people here with the same last name, so we've been using their first names. Our position in this case is that the trial court's decision has two fundamental errors that permeate the entire decision. The first fundamental error is that the trial court deviated from the standard that's supposed to be applicable to a motion to dismiss. The second fundamental error is that we believe the trial court misunderstood the distinction between a claim to invalidate a document, which was our counts 1 and 2, claims to invalidate the trust, from counts 3 and 4, which were claims for intentional interference with expectancy and a claim for unjust enrichment that often accompanies a claim for interference with expectancy. I'll start with the standard. So at the pleading stage, a prima facie showing of personal jurisdiction suffices to survive a Rule 12b2 motion to dismiss. One of the cases that we cited in our brief below is called Cannonball Fund versus Duchess Capital Management. It's a 2013 decision by the appeals court, and I'm mentioning this case because of the language of the case. There, the court wrote, "At this stage of the proceedings, the plaintiffs have a burden of production, not persuasion." The trial court...
I have a question for you.
Yes.
In deciding the legal question of whether or not the mother moved the situs of the trust to Massachusetts in the 10 months before she died, what state's law do we apply?
So we applied Massachusetts law to that analysis because she was residing, we say she was residing in Massachusetts at that point, and in order to determine whether a trust has a principal place of administration in Massachusetts, we look to the Massachusetts Uniform Trust Code. So that's section 202 and 204 specifically.
Right, but the trust says it's governed by Illinois law.
Yes.
So why wouldn't Illinois law govern where the trust is being administered?
It could be, Your Honor, but it may be a distinction without a real difference. So both Illinois and Massachusetts are uniform trust code states. So in 2000, the Uniform Laws Commission issued the Uniform Trust Code, which has been adopted in a number of states at this point. Massachusetts adopted it in 2012. Illinois adopted it in 2020. And so the provisions that we're talking about, Section 202 of the Mass Uniform Trust Code, Section 204 of the...
Well, 204 is different in Massachusetts than in Illinois.
How so, Your Honor?
Well, they're different.
So I think what...
It doesn't have this thing about the, unless otherwise designating the trust instrument, the principal place is where the person lives.
That's what Massachusetts says, correct? So
But that's not what Illinois says.
Illinois, it says the Illinois trust is the principal place of administration, if I'm recalling the statute correctly, is where the trustee maintains a principal place of business. It doesn't have the residency language except when it refers to beneficiaries. And so it says if there is no trustee or if the trustee doesn't have a regular place of business, then you look to where the beneficiaries reside. Here, this was Sarojini Rao's revocable trust. During her lifetime, she was the sole beneficiary of the trust. So whether we're looking at her place of residence as a beneficiary or as a trustee, the allegations in the complaint supported by the affidavit on behalf of Durga that was filed in support of our opposition, says that she resided in
So
Massachusetts.
the trust gets created,
Yes,
and it's an Illinois trust, place of administration, Illinois, right?
correct.
So when does that change?
It changed when she changed her place of residence,
Why?
because that's what the law says.
What law says that?
So that we are guided, we believe, by Massachusetts law on that point.
Okay, is there any, if you're wrong, if we disagree with that, is there any Illinois law that says that?
I think you would look to the Illinois Trust Code and the provisions we just talked about, sections 202 and 204. 204, as we just discussed, I do not believe has the residency for a trustee language, but it has the residency for a beneficiary language.
So one of the things both laws say is that if you want to change the place of administration, you have to notify all the beneficiaries.
It actually says you have to notify the
Qualified.
qualified beneficiaries, and qualified beneficiaries has a very specific definition.
And that would have been her.
It would have been her, so she effectively had to notify herself.
Any evidence she did that?
No, not one way or the other, although I think it is a technical gesture, and I would argue that she has no need to notify herself of what she herself is doing.
What do we do with section, or Article 2.1 of the trust that says, I reserve the right from time to time to amend this instrument in whole or in part by instruments signed by me and delivered to the trustee during my life?
Yes.
Wasn't she required to, if she was going to amend the situs of the trust, to do so in writing?
No, Your Honor. So you're exactly right. It was a revocable trust during her lifetime, but she was not required to amend the trust in order to change the situs of the trust. So she may have been required, I'm not sure of the answer, she may have been required to amend the trust to say which governing law would apply, although I'm not so sure about that. But here, it's the residency that counts. And so this argument as to where she was a legal resident, this goes to our first substantive argument as to...
Well, before we get there, you're saying there's no obligation to manifest your intent to change the situs for the trust whatsoever? You don't need to modify or amend the trust? You don't need to file a statement? You don't need to do anything? It just happens?
It just happens, especially for a revocable trust. So a revocable trust is essentially a will substitute. So when she dies, when anyone dies as the trustee and beneficiary of their own revocable trust, that property is included within your probate estate. It's essentially your property. And so any of the remainder beneficiaries of the trust, their interests don't vest until the settlor passes away, because at that point the trust becomes irrevocable. So during Sarah Jeannie's lifetime, this was her trust. She could do with it as she wished.
But the trust itself says the original place of administration shall be Illinois.
Absolutely.
And you're saying that doesn't need to be modified at all.
No,
it just happens. It just happens that becomes that provision of the trust becomes invalid.
It just happens, and in fact,
Well,
if you
so
look at...
I'm sorry. I'm interrupting you.
Oh, no, I'm good.
The statute says the trustee may, but has no affirmative duty to transfer the trust principal place of administration to another state.
Correct.
So wasn't it up to her whether she wanted to change the place of administration?
Absolutely.
So what's your evidence that she changed it?
By moving permanently to Massachusetts.
Seems like she didn't have a choice then, you're saying.
Well, she didn't have to move to Massachusetts.
But you're saying if she moved, regardless of the statute, she had to change the place of administration?
So I don't think it's that she had to change the place of administration. What I think it is that by the fact of her moving to Massachusetts, the place of administration of the trust moved to Massachusetts. She was the sole trustee of the trust. She was the sole beneficiary of the trust. When she moved, the place of administration moved with her.
At what point during the 10 months did that happen?
I would say on September 4th 2020, which was the day that her son Durga brought her back to Massachusetts, because all of the allegations in the record are that she intended this to be a permanent move. She wasn't just going to spend some time with her son, right? She went to doctors in Massachusetts. Her bills and mail were sent to her.
So let's assume we agree with you that the situs of the trust moves with the trustee.
Yes.
It's wherever the trustee is located.
Yes.
And that when she moved to Massachusetts, the situs of the trust moved to Massachusetts. What do we do with Article 6.1, in which she appointed, when I cease to act as trustee, the daughter shall be trustee?
Yes.
Why doesn't the situs of the trust move back to Illinois?
It did, I think, Your Honor. It moved back to Illinois after the daughter accepted her appointment. But when the daughter accepted her appointment, she was accepting her appointment as trustee of a Massachusetts trust.
What's the evidence that she knew it was a Massachusetts trust?
Well, she certainly knew her mother was living in Massachusetts for 10 months at the time of her death, right? So there's evidence that she was calling her mother in Massachusetts every other day. She was the power of attorney for her mother in Massachusetts, so she owed duties to her in Massachusetts. She worked through an agent, Saragini's friend, to speak with Saragini in Massachusetts, right? So I don't think there can be any debate that the daughter knew the mom was in Massachusetts. Whether she knew that by accepting the trusteeship of a Massachusetts trust, she was subjecting herself to personal jurisdiction in Massachusetts, there's no evidence in the record whether she knew that one way or the other, but there's not a knowing consent element to the statute, right? If you accept the appointment of a Massachusetts trusteeship of a Massachusetts trust, you are subjecting yourself to Massachusetts jurisdiction.
Even if you don't know it's a Massachusetts trust?
Even if you don't know. So, but remember, this is the argument that we're making under the consent statute, right? We say that the argument begins and ends with the consent statute, especially under the Supreme Court's decision in Mallory. If she accepted the trustee in Massachusetts, she's subject to Massachusetts personal jurisdiction. But if we then go to the more traditional...
Well, but that corporation seemed to know. I mean, it filed papers saying we're amenable to suit here.
Because it was a different statute, right? Here, the statute is very bare bones.
What do I get in Mallory that by accepting administration of a trust in Massachusetts that you didn't know how to place administration in Massachusetts, that solves the due process problem?
Say that again, I'm sorry.
How does that solve the due process problem?
Because under Mallory, subjecting yourself to jurisdiction pursuant to a consent statute does away with the due process analysis. That's what the Mallory court explicitly said. But even if we look at the due process analysis, right, we start with the long-arm statute. We say that she subjected herself to jurisdiction under 3A and 3C of the long-arm statute. The court accepted our facts, well, acknowledged our facts as accepted, the communications into Massachusetts, the telephone calls. I don't know if there was mail, certainly telephone calls, working through an agent in Massachusetts, serving as power of attorney for a principal in Massachusetts. But then the court essentially said, the trial court said, well, these facts don't really matter because VANAJA, the daughter, didn't intend to benefit from these contacts. And the crux of the context, the crux of the allegations occurred in Illinois. But I think what these holdings do, these explanations do, is they belie a misunderstanding between counts 1 and 2, again, the claims to invalidate the trust, versus counts 3 and 4, which are the claims for interference with expectancy and unjust enrichment.
But how does the daughter's consenting to be the trustee in 2021 retroactively affect jurisdiction for events that happened in Illinois in 2018, in 2019, 2020? I'm confused about the chronology.
So the timeline, and I know I'm coming up on my time, the timeline is that there was a series of events that happened in Illinois, some events that happened in India, and then in Massachusetts. The culmination of the events that led to the claims for interference with expectancy and unjust enrichment happened in Massachusetts over a period of 10 months. Under our state's, the elements for a claim for interference with expectancy, the claim does not accrue, cannot accrue until the decedent passes away, because there has to be continuous action upon the decedent to cause the interference. Therefore, our interference with expectancy claim did not accrue, it did accrue in Massachusetts at the time of Sarah Jeannie's death.
Does it matter that the complaint is against the sister individually and not as trustee of the trust?
No, because the actions that she performed were in her individual capacity, right? She didn't become a trustee until after her mom was dead.
I'm not deep enough in the record to know the answer to this. Your client, as executor of the estate, did he file a Massachusetts estate tax return for the decedent?
No.
Why not, if she is a Massachusetts resident when she died?
I haven't been, honestly, I haven't been involved in the Illinois proceedings.
I guess he didn't file it.
I don't know if an estate tax return was filed.
How about an income tax return for the decedent in 2021?
I don't know.
So while the mother was living in Massachusetts for those 10 months,
Yes.
did she actively administer the trust, or was she just passive and the daughter was doing everything?
So again, we haven't had any discovery yet because this was at the motion to dismiss stage. I think she was passive, but in and of itself, being passive as trustee of a trust is action as a trustee. So a trustee has a duty to administer a trust prudently. And so doing nothing is an action of a trustee that in some situations can cause a trustee to be subject to liability.
Anything else? All right, thank you very much.
Thank you, Your Honors.
Whenever you're ready, Counselor.
Good morning, Your Honor. May it please the Court, Adam Rowe from Crow, Rowe & Dunn on behalf of VANAJA SUDHAKAR. With the Court's indulgence, I'll refer to the parties by their first name, VANAJA. The trial court was correct in its determination that the long-arm statute was not satisfied, that the overwhelming evidence suggests and indicates that due process, and in particular, the notions of fair play and substantial justice all point to Illinois, and that the trust statute that my brother is relying upon, it does not create a jurisdictional basis for the claims. And I want the Court to assume arguendo that the decedent at the time of her death resided in Massachusetts. This is the claims that my brother proffers. Notwithstanding his client's affidavit or his sworn statements in Illinois that his mother was a Illinois resident at the time of her death, notwithstanding his affidavit of heirship where he avers under oath that his mother was a Illinois resident at the time of death, and that his sworn statements that the trust remained in full force and effect and had not been modified even slightly, including the section 9.11, which is the choice of law and jurisdiction, which he avers in his certificate when he accepts that these all remain in full force and effect. I want you to assume arguendo that in point of fact, notwithstanding all of that, his mother was a Massachusetts resident. That fact does not transfer jurisdiction over the trust itself. The trust in the brief cited by my brother regarding the jurisdiction, and I would respectfully suggest misapplying Massachusetts law or opposed to Illinois law, but even applying in this provision what is somewhat analogous of saying that you look to the residence, you first look to the business address where the records are kept, all of which were evidence suggests in Illinois. And they say if you don't have that because she didn't have a business, then you look to her residence. Well, that's actually wrong, because there's a preamble to that. The introductory clause to that section, Section 204 in Massachusetts, actually says that unless the trust itself
All right, so
doesn't otherwise designate.
you're doing the same thing. Why does 204 in Massachusetts apply?
It doesn't, Your Honor. With respect, it doesn't. The choice of law language is clear and unequivocal in Section 9.11 that the choice of law is Illinois law, and that the initial jurisdiction, I'm just pointing out the fallacy in even my brother's argument, that even if it were somehow Section 204, that the introductory language says unless otherwise designated in the trust instrument. So the original jurisdiction is clearly Illinois. Now, the analysis doesn't stop there, because my brother is correct that the trustee can effectuate a change of jurisdiction. And in order to do that, she has to do a couple of things. One, pursuant to the terms and conditions of the trust indenture itself, 9.11, and also pursuant to Illinois law, which is the notice requirement, where she has to spell out her rationale for so doing.
So what does she have to do to change the site?
She didn't do anything.
No, what would she be required to do?
What would she be required to do?
Yeah, exactly, precisely
Well,
what did she
first,
need to do?
pursuant to the terms of the trust, 911, she would have to make a determination that a change in locus is in the best interests of the trust itself. There has to be an internal determination that she makes in her own mind. And that's step one. Step two, under Illinois law, she has to specify that in a written notice that she provides to qualified beneficiaries.
Why does she have to specify why? She has to specify that under the statute. I don't see why it says why.
Well, it has, I believe the statute indicates she has to specify and I'm looking specifically, Your Honor, at Section 3-108 of Illinois' adoption of the MUPC, and paragraph 2 sub D, I'm sorry, it's paragraph D sub 3, that the notice of proposed transfer must include, and dropping down to 3, an explanation of the reasons for the proposed transfer. So I would respectfully submit that she has to manifest her intent to transfer, and that merely changing her residential address.
Could you just give it to me again? That was 204D
D sub 3.
sub 3.
And it's
She's got to notify the qualified beneficiaries.
which would be herself, Your Honor. But it's also there, I would submit that it's not just form over substance, that there's a rationale that she has to put there, and which is consistent with the trust language saying she has to make an internal determination as to it being in the best interest. It's not just her moving. There are many reasons why a trustee may want to keep a trust in a different location than where they reside. A Massachusetts trustee might want to keep a trust in Florida if it's an income-producing trust, for example, because there's better tax, more advantageous tax laws.
Does she need to amend or modify the trust, or is the notice sufficient to make the change?
I would respectfully submit that there would have to be a written modification, as Justice Grant questioned, with respect to the sections regarding changing the situs. I'm not 100% sure on that answer, Your Honor, because the language of Section 9.11 says the original trust, and it says a determination in the trustee's subjective mind has to be made. But regardless, the defendant, or strike that, Mr. Rao, signs a certificate where he says, no, this has not been modified. But let's assume further that not only is she a resident of Massachusetts, but even though she hasn't manifested any intent, by the way, my brother was asked, did she do anything to administer the trust here in Massachusetts? There's zero evidence, not a scintilla of evidence suggests that she did anything to modify or to administer the trust. And then they cite footnote 5 in their principal brief, which says, well, maybe she's liable for not administering it here. But the fact of the matter is, there's no manifestation of any intent to transfer the locus of the trust, and no manifestation that she ever made any determination in her own mind that such a move of the locus would be in the trust's best interests as mandated under 9.11. But let's assume further that not only was she a resident of Massachusetts, but that somehow magically the trust becomes a Massachusetts trust. Even if that were the case, it still does not subject my client to jurisdiction in Massachusetts under Massachusetts law, which I would respectfully submit does not apply. But even if you go a step further and say, yes, you know what, we're going to apply this statute, section 203E202, and say that this applies to this Massachusetts jurisdiction to trustees. The Mallory case, which my brother cites, I think stands for a diametrical proposition than is being suggested to the court. Justice Gorsuch, writing for the plurality, frames it on consent, and it's upholding the Pennsylvania insurance case, Justice Holmes' case. And the concept there is that by doing business in the state, you consent to the jurisdiction. There's a voluntary element, according to the plurality decision from Justice Gorsuch, where you're voluntarily submitting to the jurisdiction of doing business by having a registered agent, by having a certificate of the corporations in that forum state. Justice Holmes went a step further in the earlier decision and said, no, it's even possible we'd have a different decision if they didn't have a registered agent. Justice Jackson, in her concurring opinion, would probably frame it as, no, it's a question of whether or not there's been a waiver of an affirmative defense. Has a party voluntarily waived an affirmative defense? There's not any evidence before the court whatsoever that VANAJA believed that this was a Massachusetts trust. And with respect to my brother's suggestion that applying Massachusetts law, that the statute itself doesn't have anything to do, doesn't say anything about voluntary consent, he's correct. Applying the law to the facts of this case, however, would violate due process and would be unconstitutional. And the reason for that is because Mallory doesn't say you throw out due process. What Mallory says is that there's another path to it, one that's been long recognized in the Pennsylvania insurance case. It's one where it's based upon consent. The record before the court indicates, to the contrary, that the parties themselves signed affidavits, essentially, their certificates under oath in the Illinois proceedings, that she died a resident of Illinois. The trust, anybody looking at the trust on its face, it references Illinois law. The acceptance of trusteeship references Illinois law. So there's no evidence that my client somehow was voluntarily agreeing to be the trustee of a Massachusetts trust. Even if she were taking it another step further, there's no reason why her actions in accepting a trustee, if we were to assume arguendo that it were a Massachusetts trust, should bootstrap the claims for her actions prior in time that existed before she became such trustee. In fact, the claims don't relate that are on appeal. They haven't appealed the claims related to the invalidity of the estate plan. They've only appealed the undue influence, or the tortious interference rather, and unjust enrichment. It's the same operative facts behind this alleged scheme, all of which is being litigated and has been litigated for the past 2.5 years in Illinois. And I respectfully submit, Your Honor, that due process, and the trial court got it spot on, overwhelmingly points to Illinois. I've got a 68-year-old housewife who is a retiree on the one hand, versus her brother, who is a sophisticated businessman albeit under federal indictment, who has real estate holdings, who is litigating the case already in Illinois, where he's, by the way, brought an indispensable party, his nephew.
Counselor, before you run out of time, I understand why you've been doing it, but you've been going through, even assuming this, even assuming that. Could you give us, without any assuming, how you think we should rule?
It's a no-brainer, Your Honor. This is a case with respect. This is a case where
I mean, but what theory should we be, in your view, what theory should we be ruling on? There's a lot of different ways to rule on this.
The easiest thing to do and I think it is a two-prong analysis. Number one, does the Massachusetts statute in and of itself create a jurisdictional basis? The answer is no, because it's not, Massachusetts law doesn't apply, number one. And number two, even if it did, it is and remains an Illinois trust because the location has never been modified. That's the first level of analysis.
When you say the Massachusetts statute, are you talking about the long-arm statute or the trust statute?
The trust statute, Your Honor. That the trust statute, I would submit, doesn't come into play, but even if it did, it's still an Illinois trust. It was, and there's been no manifestation of intent to transfer the locus of the trust. Illinois trust. That's analysis number one. Number two, I would submit that the court, even though there's all sorts of evidence that she is a resident, that the decedent was a resident of Illinois at the time of her death, court doesn't even need to reach that conclusion because it can look to the fundamental fairness argument under a due process clause analysis and indicate, as the trial court did, that everything overwhelmingly points to Illinois, where the case has been litigated and is being litigated for the past 2.5 years. The corpus of the trust is there. The recipient witnesses are there. The settlor created it at that point in time when she was clearly and unequivocally a resident. I don't think you need to reach the question of her residency. I think that just looking at the third prong of a due process analysis, where you can say, does this comport with traditional notions of fair play and substantial justice? And on that question alone, I would respectfully submit that the conclusion should be having this case proceed along a parallel path to the one in Illinois does not comport with substantial justice and fair play.
All right. Well, thank you much. Thank both of you. We'll take it under advisement.
Good. Thank you, Your Honor.
All right, I'll call the last case of the day, number 24P40, Avalon Building Systems versus KULIOPULOS. Counselor, whenever you're ready.
May it please the court, my name is David Paliotti, and I will be representing the defendants in this action, the White Sands Beach Club Incorporated and Maria KULIOPULOS. I do have Mrs. KULIOPULOS with me, who is hard of hearing, and I would ask if the court would indulge her and let her sit in the chairs behind me.
Sure, absolutely.
Thank you.
The court would also indulge Mr. Oliveira.
Yes, that's fine. Can we pause the time a second? All right, everyone come forward, but sit behind. All right.
Thank you.
Let's continue.
Thank you, Your Honors. While I make my presentation, I would ask you to keep a number in mind in the back of your heads, and that number is $844,000. And I will very shortly explain the significance of that number to you. By way of background, Mrs. Kuliopoulos and her late husband has operated the White Sands Hotel since approximately 1990. Mr. Kuliopoulos became ill shortly before the fire in October of 2014, and Mrs. Kuliopoulos was tasked with taking over the running of the business. In October of 2014, there was a fire that destroyed a large portion of the hotel, approximately 19 of the units. So after the fire took place, Mrs. Kuliopoulos decided that she would, rebuild the hotel and that she would obtain a permit, to do so. And she didn't want to lose her grandfathered status since the hotel had been built in 1990, and obviously the building codes and zoning codes had changed since then. So she went through that permitting process to enable herself to get a permit. And after a little over a year and a half, and going through all the local boards and departments in the town of Truro, she obtained permission to rebuild the 19 of the destroyed units, provided she comply with certain requirements. And the primary requirement was that she obtain a building permit and actually complete the construction of the new units by October 30th of 2016. So she endeavored to do that. She hired an attorney to represent her at these planning boards. She hired her own architect and engineers and paid them. So in January of 2015, Mrs. Kuliopoulos decided that she would try to put a modular building, on the property.
We're familiar with the facts, and you've got a lot of issues to cover, so can we get right to why do you think the jury's verdict, judgment in favor of the plaintiff was incorrect?
Okay. Certainly, Your Honor. The way I see this case is I look at a judgment that's now worth $844,000 with interest against someone solely for deciding to go with a different company, different modular company, at substantial additional cost to her. She didn't do it to save money. She didn't do it out of avarice. There was no evidence of her leading Avalon along, which was far more sophisticated in the business world than she was. And in fact, there was never any meeting of the minds between the parties that would justify a finding by the jury of a breach of contract.
Are you challenging the jury's verdict that there was a contract between the defendants and Avalon? Because there clearly was. There was, at the very least, the preliminary agreement, correct?
Yes. Yeah.
And the jury verdict was, the jury was only asked to decide, was there a contract between Avalon and the two defendants? There indisputably was. So I'm trying to understand, what are you challenging now?
I'm challenging I agree with you 100%. There was a contract. It was called a preliminary agreement, okay? It was essentially a letter of intent. And what it provided was Mrs. Kuliopoulos would pay the sum of $5,000 as a non-refundable, quote, plan, close quote, deposit, which she did. That's page 177 of the appendix, which is not disputed. And in exchange, Avalon agreed, and I quote, Avalon services will include up to 20 hours of staff time to consult, design, draw, and estimate for your project, including 2 sets of preliminary drawings if required, and 1 set of final engineered drawings. Well, they never did that. What happened was Avalon said to Mrs. Kuliopoulos, we want you to hire this architect, Joe Luna, from Luna Design. She hired him, and she paid him directly for all of the engineering services.
Right. The issue, I think, is what happened after that preliminary agreement was signed, right? Mm-hmm. Mr. Oliveira testified that he engaged over a 3-year period in extensive general contractor work on behalf of the defendants. He coordinated with the architect, he coordinated with the engineering company, coordinated with the company that's designed the modulars. He worked with lawyers, he worked with the Truro town officials. And so the question is, I'm trying to understand what is your argument that the jury got wrong with respect to all that subsequent conduct? Because you're not challenging the existence of a contract. Mm-hmm. You're saying Well, that work that he did wasn't encompassed by any kind of contractual relationship? Is that, I'm just trying to get to like the legal, why is the jury's verdict wrong?
Okay, thank you. The jury's verdict is wrong because a preliminary agreement does not require my client, as a matter of law, to purchase a modular home. What it does is it's essentially, as I said, it's a letter of intent. There's nothing in that preliminary agreement, and it's called that, nothing in that preliminary agreement as to the price that will be charged, a formula for coming up with a price, such as a per unit price. There's no specifications whatsoever for the modular building that's going to be supplied. They don't even identify a manufacturer of that modular building. And it specifically states there will be formal contracts to be executed at some point in the future. And even there's no deadline for executing these contracts.
Do you dispute that Avalon and Mr. Oliveira did considerable work on behalf of the defendants at 2016, 2017, into 2019? They did all these different things, right? You agree? That's in the record.
No, absolutely not. I absolutely disagree with that. I don't think the evidence supported that a bit.
Well, that was Mr. Oliveira's testimony of all the things he did. You say that we should discount that now?
No, what I'm saying is Mr. Oliveira also testified that between 2017 and 2019, they did little, if anything, because once Mrs. Kuliopoulos lost that grandfathered status, she had to start all over again from scratch. So between 2017 and the better part of 2019, she had to secure new permission from the planning board and the other boards to be able to put a new building on that site. So there wasn't any work for Mr. Oliveira to do during that time, nor did Mrs. Kuliopoulos ask him to do anything. And in my brother's brief, he claims, she led him along and she requested him to continue doing services. But the only evidence he cites to that is a letter in December of 2015, and then a communication prior to October of 2016 when she needed to get the building constructed so she could do it.
No, there is extensive evidence from Mr. Oliveira about all the things that he did. That's what he testified about at trial, right? And so what are we supposed to do with that testimony? Of all that he was coordinating with on the project, with the lawyers, with the engineering. He was doing general contractor functions.
Okay.
So are you saying that's not suitable evidence, or that there is no contractual relationship that existed into that? I'm trying to understand what is the argument that, because it's, because the standard for reversing a jury verdict is very challenging, right? So I'm trying to understand what exactly is the clear legal error here that supports reversal.
Okay. What I'm saying is that to the extent he rendered these services, and you're saying it's undisputed, there's sufficient evidence.
It's his testimony, which we have to credit on, right, given the jury verdict in his favor.
He may be entitled to a quantum merit award based on that. The problem is the jury found against them on quantum merit. And what they found was a breach of contract. But they couldn't have found a breach of contract for my client to purchase a modular home or to spend $1.3 million on site work. Every time Mr. Oliveira presented my client with a contract, and he admits to this in his testimony, she said, no, it's price, I can get someone to do it cheaper.
But what do we do with the evidence that notwithstanding the fact that there wasn't a more complete contract, your client kept asking him to do more work? So for example, there's the October 25th, 2016 email from your client to Mr. Oliveira. You should meet the deadline of October 28th in filing for the building permit, although the issuance of it will be after the two boards approve the changes. And this was at a point in time when she was in receipt of the two-page letter from the building inspector saying you're not going to meet the deadline, and she didn't tell Mr. Oliveira about that.
Well, he knew about the deadline because submitted into evidence is a letter to him from Attorney Snow, who was representing Mrs. Kuliopoulos, reminding him, look, we're butting up against a deadline. Are you going to be able to make it?
But from this email, it looks like the deadline is for filing of the building permit as opposed to completion of the construction.
Now, if you look at the permit itself, which should be in the trial exhibit, it specifically said the building had to be constructed by October 30th. And what the building department was saying is, look, I could give you a permit now, but it's physically impossible for you to get that completed between now and October 30th. But to answer your question a little better, what she asked him to do in that communication was get a permit. She didn't ask him to do $1.3 million of site work, and in fact, that 1.3 included the foundation, which she hired someone else to do. And even Mr. Oliveira testified at trial that, and I'll quote to you if I may, that we could never get a deal. We could never get it going. That was his exact words at trial.
Ever get a formal deal, but he's communicating with your client. She's visiting the factory with him. They're in very frequent communication about this project.
Yeah.
He's doing general contractor type functions, all for a 3-year period.
Right. But how do you...
So the fact that and you didn't ask the jury to the jury wasn't asked to sort of say, was there a contractual relationship that extended beyond the preliminary agreement? So we have to assume, I think, that the jury found that.
Even if you assume that, that brings you to damages. How does the jury award breach of contract damages for lost profits? Because that's what they asked for. They said, we want lost profit damages, or if you don't find a contract, we want quantum merit. So they did find a contract and awarded lost profit damages, but they based it on an imaginary $2 million contract. And what Mr. Oliveira testified to was, we don't get paid on the hour. We don't get paid a per diem. We get paid based on the profit in selling the modular home. So say the modular home costs $500,000 to him, he sells it for $625,000. That's his profit. That's how he gets paid. And he testified at trial, it's a 13 to 15% profit. So the only contract that he sent to them with a specific amount was the one for $759,000. So what we're saying is the judge should have either granted a new trial or ordered remitted her in the amount of $113,000, which would be 15% of that $759,000. But you've got to keep in mind...
Did you present countervailing evidence of what the project cost would be? I understand that you say Mr. Oliveira's testimony was speculative. Did you present, well, if this project had come to fruition, this is really what it would have cost? Was there evidence that was countervailing to that?
The only evidence would be the cost of Mrs. Kuliopulos purchasing a modular building from someone else, which was actually at a higher cost than what was being quoted. But the real issue here is there was never a meeting of the minds that would justify damages beyond damages flowing from this preliminary agreement. You know, how can you award lost profit damages without knowing what the cost of the modular home was? And if anything, I would submit it was Avalon constantly bullying Mrs. Kuliopulos and keeping itself inserted in this project when there really wasn't anything for it to do for a 2.5-year period, and then they kept trying to sell her.
Didn't your client have some obligation? There's clearly a contractual relationship established in 2016, and it continued with both parties' conduct engaging in a relationship that continued. Didn't your client at some point have an obligation to sort of say, the deal is off, I don't want anything more to do with you, you're not working for me, this is over? And that happened in 2019,
Yeah,
but there's a
that did
3-year
happen.
period where...
But it wasn't until 2019 where she obtained permission from the planning board to actually, recommence the project. But you've got to keep in mind, they butted heads constantly from the time of 2016 to the time that she decided to go with someone else. And I would agree with you that they should get some compensation if, in fact, she went with someone else for an ulterior purpose, to save money. No, she spent $164,000 more than if she had stayed with him. She could not get along with him. They could never agree on terms. Whenever he would propose, look, we'll do the foundation for this price. No, I don't agree to that price. It's too high. I got someone else, someone better, who's going to do it for less money. And she did do that. He also made a proposal.
I have a question for you about your statute of frauds instruction argument. As I understand it, during the charge conference, when your trial counsel asked for an instruction on statute of frauds, the judge said, well, this wasn't pled. But you're now saying, but it was pled in the answer. Didn't trial counsel have an obligation to say to the judge, oh, no, wait a minute, it was pled in the answer?
My recollection is he did. I wasn't at the trial, but my recollection from the transcript is he did, in fact, say, no, Judge, we did plead it. It's in the answer to the amended complaint, affirmative defense, I think it was number 3.
All right, so assuming that's not the case, would you agree? If that's not the case, would you agree the claim is waived?
No, because it was actually pled. I think it was a
But
mistake.
why, if a judge says, hey, you didn't plead it, and instead of saying, well, you did plead it, you just say, okay to the judge, wouldn't that waive the request for the instruction?
It's difficult for me to disagree with you on that, Your Honor.
Is the statute,
If that
was the
happens.
statute of frauds issue raised in the motion for summary judgment?
For a summary judgment or for new trial?
Motion for summary judgment. So in other words, is the question of whether or not the statute of frauds applies to these modular buildings, is that a question of law, or a question of fact, or a mixed question of fact and law?
I think it's a mixed, and we did cite to a case, Burnham Homes, I believe is the name, where they said a sale of a modular building is a sale of goods, and it's subject to section, I think it's 2-103.
But that's a modular building that doesn't need finish work on the exterior, et cetera.
Every modular building needs finish work on the exterior.
Isn't the statute of frauds, the application of the statute of frauds, a question of law? Purely? It's not something that goes to a jury. Can you point to any case where it's been submitted to a jury?
Other than the Burnham case, and I don't recall honestly.
Our
if that
precedent
was.
says it's a question of law, so I assume that's something that wouldn't normally go to a jury. I know that wasn't the basis for the judge denying it, but that seems to be a fundamental problem.
I would think as an initial matter, it would be a question of law, and then if it does apply, then you'd apply the facts to that law to see if it precludes a contract from being formed.
On the duplicative damages, was there any request that the jury be instructed not to have duplicative damages?
Well, the instruction to the jury from the judge, and also in my brother's closing argument was you can award two types of damages. You can award lost profit damages if you find a contract, or if you do not find a contract, you can award damages under quantum meruit. And I would suggest that the damages awarded under Chapter 93A were clearly under an unjust enrichment quantum meruit theory, because they really don't comport with anything else.
The 93A damages? But the judge gave an extensive kind of analysis, all the different bases for that, and they don't really overlap with the lost profit theory,
Well,
as I read it.
I would just say the evidence, there was nothing in the evidence to support award of $74,800 under Chapter 93A. Likewise, there was nothing in the evidence to support an award based on an imaginary $2 million contract, which it's clear from the testimony of Mr. Oliveira, Mrs. Kuliopoulos never would have agreed to. It was way too expensive, and it was way beyond the scope of the preliminary agreement. And I think that's very important, because the preliminary agreement only talks about buying a modular home. It doesn't talk about doing $1.3 million of site work, including a septic system and all this other stuff that's completely separate from a modular building.
All right, I think we'll have to leave it there.
Okay, thank you, Your Honors.
Thank you very much. Counselor?
Good morning, Your Honors. May it please the Court. My name is Paul Hogan. I represent Avalon Building Systems, Inc. I was also the trial attorney for Avalon in this case. When we approached this case, we had spent a lot of time on the project and not been paid. You've seen the preliminary agreement. You've seen that. I can tell by your questions you've really looked at the evidence. We approached the trial under two alternative theories, quantum meruit or breach of contract, and we took those to the jury. We also added the 93A. It should be mentioned that we had before the court a year before the trial or so a motion for real estate attachment, and one was granted for $150,000 by Judge Caputo. And I would suggest to you that this counsel believed it was based on quantum meruit on that award.
Well, since the jury didn't find for you on quantum merit.
No, they didn't. But
okay, so let's dig into the contract theory,
Sure.
if you don't mind. What exactly justifies the award of contract damages beyond the preliminary agreement? What is your theory of there being a continued contractual relationship? I just articulate this in legal terms.
Yeah, okay. Mr. Oliveira, he's a licensed construction supervisor. He put his license down for all the permits or all the actions before the town. And he is his company is a general contractor. They do the whole project. You just don't buy modular boxes and stick them on a foundation. This was going to be an 18-unit hotel on the Cape in a flood zone. It was going to have septic. It was going to have parking lot. It was going to have lights. It was going to have power coming in from the street. It was going to have...
I'm sorry, I know the facts. I'm just trying to get to what's your legal theory here, right? Because we all agree there's a preliminary agreement that was written. Let me finish.
Avalon
let me finish.
I'm sorry.
There was a preliminary agreement that was written, and that there wasn't anything subsequently agreed to in writing. So what exactly is the contractual basis for the damages that the jury awarded for lost profits exactly? What is the theory that there was a continuing contractual relationship? In legal terms.
I'm sorry. We argued to the jury, and I believe they believed, that it was the preliminary agreement plus the second agreement for the $759,000. But in that agreement and in my brief, it talks about Avalon expects to do the site work, expects to do whatever the town requires for the project, as well as hire subs. That wasn't signed, but it was produced to Mrs. Kuliopoulos a few days before the run-up in September 16, where Avalon was trying to get a permit, and the email that Justice Grant talked about was issued by Mrs. Kuliopoulos that go ahead, and we take that as affirmation of the deal, that we've got these plans, we've got this project, we're going to go apply. You just told us it's okay. We've had this document in front of you. It's very detailed. And you said okay. So we take that as an affirmation of the contract. And it wasn't repudiated for the next 3 years. It goes all the way to, again, August or so in 2019 when they have a pre-construction meeting. And at the pre-construction meeting, Avalon's ready to go. The architect is there. Mrs. Kuliopoulos is there. Mr. Oliveira, representing Avalon, is recognized as a general builder. And the foundation permit has been approved. And there was a big discussion during the trial. You don't get a foundation permit without the town having an idea that it's going to approve the whole project. And that goes... Mrs. Kuliopoulos' son testified differently. He testified that he expected the foundation permit will come first, then a contract. That's not how it goes. And in this whole case, they've had a peculiar look at how construction goes. Mr. Braun, who was the building commissioner, he looked at the whole, he's not just approving the boxes of the foundation, he's approving the whole project. The septic, the site, and coastal engineering was mentioned in the evidence.
So just to get back to my question, your theory is that the second contract, which was not signed by the defendants, nevertheless became effective because the defendants affirmed their agreement to those general terms, and that the continued actions of the parties over the next 3 years were further affirmation of the terms of this agreement, even though it wasn't reduced to writing. Is that correct?
That's correct, and that's what I did argue to the jury. But I also have in my brief promissory estoppel that the way that the defendants conducted themselves, that they're stopped for our detrimental reliance on staying with the project, doing all these things. And so on those two theories, ratification that I argued to the jury based upon 1, 2, 3, the preliminary agreement, Mrs. Kuliopoulos' sort of affirmation of it around September of 16, and then finally the contract coming out with those particular terms. So
Isn't it better to get this in writing? I mean, if your client's a general contractor, right? And general contractors do a lot of different things, and sort of you're really taking a risk here by sort of taking all these actions over a sustained period of time and not having any kind of obligation from the other side in writing as to how you're going to get paid for it.
Yeah, I've been representing Avalon for 30 years, and there's been a lot of contracts. This is one of the few ones that got around the corner, and that's why we argued two different theories.
Do we know, I know this is a little bit like reading tea leaves, do we know how the jury arrived at the $275,000 for breach of contract in the verdict?
Yes, purely the testimony of Mr. Oliveira. I asked him, what did he think the project was? And we were talking about the entire project. We were talking about the foundation, which was about $129,000. We were talking about the $759,000 for the boxes, but then the septic was probably another $700,000, the parking lot. And by the way, if you look at the picture of the motel, there were decks and walkways that had to be built. Each unit is entered from the outside. And so these decks and walkways are about another $100,000. That would have been part of what we thought was the project. And then one of the things that the utilities that come into the service, there's a suppression line for the fire, for the sprinklers, the sprinkler systems also. So Mr. Oliveira, he's a graduate of Worcester Polytech. He worked for the Flatley Company for many years. He knows a lot about construction. He said $2 million. It wasn't objected to, and it was never contradicted. One of the things that
So where did the $275,000 come from? Was his testimony somewhere?
The lost profit.
Oh, okay. And then
came from Mr. Oliveira.
And then the $74,875.
That came from the jury, but one of the things that the jury considered was Mr. Braun was a very key witness in this case. He was a very powerful witness. And Exhibit 2 is his letter saying, you're not going to make it. We're not going to approve you. And he testified that he wrote that letter with consulting with counsel because the defendants had sued the town of Truro and sued each individual planning board member. The deadline of October 30th was a settlement agreement. And my brother talks about, well, we're getting permission. This was very contentious. It took a year to do anything after the fire. Then they finally get going. So one of the things that surprised the jury was that 2 years after Avalon had been taken off the job, the project's not open.
I don't think that was very surprising. You mentioned that in your opening.
Did I?
Yeah.
I'm sorry. But what happened was the power wasn't coordinated with the, there's not enough power on Route 6A coming up to the site. And one of the important exhibits was that pre-construction meeting that I talked about. So on page 173 of volume 1. And in that, Mr. Oliveira states that he's waiting for the electrical loads from LVR, that's an engineering company. This is on page 175 or 3 of the exhibit. And he'll begin to work with the local power company, Eversource, regarding the new electrical service. Joe Luna advised he will speak with Larry Roy regarding this. What I'm trying to point here is that Mr. Oliveira is a builder. He's going to build the whole project. If he was just doing the modular pieces, he wouldn't be involved with the electric coming in. But he had the foresight to know that this was required. This peculiar construction process that the defendant seemed to think can work or wanted to work defies what the town of Truro wanted. The town of Truro wasn't just looking at modular boxes for a permit or a foundation. They were looking at everything. And the engineering company that was hired by White Sands was falling behind, and Mr. Oliveira testified because he he learned that they weren't being paid. And so here's defendants trying to get this thing done fast, but they're not accomplishing what they need to do to get the project done, and then they're blaming Avalon for actually stuff that was really their responsibility. And the other thing that I wanted to point out to the court.
Well, can I ask, what do we make of the testimony from Mr. Oliveira that Mrs. KULIOPULOS, the defendant kind of resisted his role as a general contractor and was kind of independently talking to other subcontractors to his frustration? It seems to me like he knew during this process that there was some resistance to the notion that he was serving as general contractor for the project.
Well, he may have he may have known that she was trying to do stuff, but he always took the position that he was the GC and that he was responsible for the whole project. His name was on the permit. He was the one that Mr. Braun from the town was talking to and looking to. He's the one that was dealing with Mr. Luna. He's the one that was dealing with Coastal. And you can't build it that way. One of the reasons I put the statute in on the building in my brief is that once you put your name on the permit, you're responsible for the whole project, not just pieces of it, the whole project. And that's what he believed. And that's why my brother has said that.
Well, there has to be assent by, I mean, it's one thing what he believed, but there has to be assent by the other party that you're carrying out this role on their behalf. And I guess if we just sort of say, well, the jury appeared to find that there was a contractual relationship that continued, but there certainly was evidence that the defendant was not fully on board with this understanding of him serving as the GC for all 3 years.
You know, the evidence didn't become open. You know, behind the curtain there were some things going on, there were some suspicions, but it wasn't until that October of 19, and I under cross-examination of Mrs. KULIOPULOS, I got her to admit that she had hired another licensed builder about 12 days before terminating Mr. Oliveira, and there were communications from the defendants to Avalon to do the foundation or to do certain things. Meanwhile, she's working in the background to try to get rid of him, but not telling them. In fact, there's an email to the building department to take his name off, but she doesn't tell him. And it goes just like what happened. There's another 93A thing when she got the Braun letter in August. She doesn't tell him, yet she tells him, let's go, let's get it done. And then the lawyers write a letter saying, well, we'll go and ask for an extension. And I said to the jury, they're asking for an extension to the people that they sued. Individually, they sued the planning board members. And she thinks, or White Sands thinks, that the town's going to say, yeah, okay. They didn't. They said, we held you to that. There were 24 conditions that she was supposed to meet. 4 of them she wasn't meeting when she got the Braun letter. The biggest one was site plan review. And site plan review is huge. Where are you going to put the septic system? Where are you going to put your foundation? Where are the levels?
Your time's almost up. Can you just address the statute of frauds issue? Is it your position that this was waived, and how so?
So I will say that at first, Judge Perino believed that it wasn't part of the defenses. But in fact, it was, because he was looking at the original answer. It was an amended answer, and it was. But we had a motion and we had an argument on it in front of Judge Perino. And I argued that these aren't fungible goods. These are specially made elements of a building that goes to a whole project. You just can't take these boxes that we provided and sell them to somebody else. So that's number one. Number two is, I also argued that it could have been built in a year. You could have done this in a year. But we said that the statute of frauds doesn't apply. We also said, because of detrimental reliance, there's a case that says that the statute of frauds doesn't apply. I quoted my brief. I think it's at the end of the brief. But that's, and Judge Perino came down on our side on the question.
Do you have a position as to whether it's an issue that should be submitted to the jury or decided by the judge?
I thought it should be decided by the judge. Question of law. One of the things I wanted to mention, I'm sorry my time's running out, but I told you that we came forward with 3 counts. They came forward with counts against us. And they were looking for $3.6 million against us coming into the trial, and the jury heard about their counterclaims. And the counterclaims were based upon these statements. Number 9, Paul Oliveira, as president of Avalon, promised Maria Koplos, as president, I'm quoting their paragraph 9 of their counterclaim, promised White Sands that Avalon could complete the grandfather building by deadline, and further promised that Avalon was partnered with Signature, who would provide the modular. And then they're suing us for the 3.6 because we didn't make it. That tells me they believed there was an agreement. That tells me that Avalon had obligations that they were suing on. Now, during the trial, they brought no evidence in of any of this, and I motioned for a directed verdict on that, and it was allowed. 2 of their counts were denied. And I'll tell you, one of the reasons why they didn't bring in evidence is because they were saying that we were responsible for being late, and Mr. Braun was one of the most powerful witnesses there, and he said it wasn't being made on time, wasn't going to make it on time, and stated the 4 reasons that were really the owner's fault.
All right, just for the record, I let your friend go over, so I let you go over a little too. But I think we'll leave it there. Thank you both for your arguments and briefing in this case. I'd like to thank all the attorneys who were here today. I'd like to thank our court officer for maintaining order, our timekeeper for maintaining order in a different way. And with all that said, court will stand adjourned until tomorrow at 9:30 a.m.
All rise.
Good job.
We'll stand at recess.